Morning, Ms. Levy.
Morning.
And you were charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 16th, 2025 at 2:02 a.m., the officer was dispatched in an attempt to locate. The officer was advised the defendant's sister was concerned for her well-being after not hearing from her. The defendant's sister stated her last known location was the Den, a bar, where she got a flat tire. While searching the area, the officer located the defendant's vehicle at the entrance of the University of Houston, and a witness was flagged down to assist changing the defendant's flat tire. The witness stated he observed the defendant as the sole occupant of the driver's seat of the vehicle, and the surveillance video showed the defendant's vehicle in motion at the time the witness came into contact with the defendant. The defendant was identified with Texas driver's license, and the officer made contact and observed a strong odor of an alcoholic beverage, red, glossy, bloodshot eyes, and slurred speech. The defendant admitted drinking a wine cooler earlier in the day, and standard field sobriety tests were conducted. The officer observed the defendant to be unsteady on her feet as she walked to the sidewalk, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 1 out of 4. The DIC was red and the defendant consented to breath. The results were 0.185 and 0.181.
And you're telling me there's video of her driving?
Yes, Judge.
Ms. Levy, I'm going to find that there's probable cause to go forward with the case. Have you run your license and any prior to BIs?
Driver's license is eligible and no priors, Your Honor.
Okay. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you consume alcohol, illegal drugs, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand, ma'am? Would you like to apply for a court-appointed lawyer? Okay, I'll give you an application. I'll take a look at your numbers, and if you qualify, we'll provide you a lawyer today. Okay, just everything's fine. Don't worry. Just be safe. Okay, just don't. Okay, I don't want to talk about the case. Let's have you fill out the application, then I'll have you talk to a lawyer today. Okay, ma'am? Please.
Yeah.
Good morning.
Hi, come up. You're a mom?
I am.
How are you?
Good morning.
Thank you so much for coming today.
Appreciate you for having me.
You know, Mr. Hall, so with the 4 open cases, you're lucky to be out. You know, you really need to listen to mom so that a 5th case doesn't occur. It's not going to go well if you pick up a 5th one. Do you understand?
You have to excuse me, I'm sorry.
It's okay.
They're trying to do 2 medicines on him. It doesn't have him hearing, if it makes sense. He's listening, but it has him, if you speak, he's dragging. And I'm okay with that because I could control what's going on. As I was there, I work in it. Everything was actually with one big sheriff department. And I work with the homeless. I came out of engineering because he taught me 2 things. I have to pay attention to what's going on at home and not just give love to people on the street. It makes sense, right?
That's great. That's wonderful.
I've done my homework recently, these big class situations. His grandmother and his grandfather is dealing, they had mental ideations as well. So it triggers. Mom says, be careful who you choose, but we can't be careful who you choose, right?
Right.
So I'm holding on gracefully to this. You have to excuse my appearance out there in cold gray.
Oh, please, you look great. But my concern is that please tell me he's living with you?
Yes.
Wonderful. Okay.
As I said, I'm bringing paperwork together to get custodial.
Guardianship. Okay.
To get placement to save it.
You know, I'm happy to, whatever you need, we're happy to give you. You know, we have a lot of resources here that we can always, you know, try to help you with, you know.
Appreciate you.
All you need to do is ask, you know, if you need tablets, cell phones. We can also do evaluations to see, you know, how we go forward. So I'm all ears and I'm with you. Whatever you want, you know, whatever conditions you think are appropriate, we can put on it.
We just had an evaluation on the.
Is mom's the CW in the cases? Or?
So Judge, these are old cases from what I remember, 2022,
So the-
ID, trespass.
Well, we have one terroristic threat of a peace officer or a judge. Is that right? I just,
Okay, this is what happened.
no, don't. I just,
We just did a psych evaluation
okay.
and we were in the room. I hope I-
No, let's not, don't. It's really, it's,
I'll talk about that right
yeah, that's something that we can do later, but at this time, I will leave him in your care, your, whatever you need, we're here to help you out with. The only thing I'm gonna ask is just you guys, just please stay in touch with Evita.
Yeah.
She will help you out.
Yeah.
And I just don't want a fifth case, that's it. I'm with you. So how long do you want to set it out, Kavita?
I think maybe 6 week, the evaluation, all the medical together and talk.
Okay. Okay. I'm gonna waive his appearance. That way he doesn't have to waste his time coming to court. But just be nice. Self-control. All these cases are because of no self-control. You get upset and you wake out. But think, it's okay. We all get angry. We all do. But just think before you act. Think before you speak. That's it. Listen to mom. If you ever need anything, come back and I can help you out with whatever you need. Just say the word. Okay?
Judge, in regards to bond conditions, how did you want to handle that?
So the bond conditions that I'd like, it's just no contact with ever the terroristic threat cases and just no weapons. That's all I would like. It's not, my concern is that it was a healthcare provider, because that's what I was thinking. Is that someone that he's currently seeing? Do you know? Alex, who in the
In the
most recent case, who's the complaining witness?
most recent case, let me see. It says the reporting party.
Oh, that case is upstairs. It's not even with us. I'm sorry.
Your Honor.
So disregard it. I thought it was with us.
Yes, Judge.
So the only condition is just no weapons. That's it. Okay. And just stay in contact with your lawyer. Okay. Absolutely. Mr. Halsall, good luck, bud. All right. Okay. Thanks. Good
Thank you, Judge. May you be excused?
morning, Mr. Newman. Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 15th, 2025, the officer was dispatched to Texas Southern regarding a male on campus possibly carrying a firearm. The caller provided the name and dispatch ran through arms and located a recent picture and a trespass notice. The officer observed the defendant walk into the library, immediately walked out accompanied by a second black male, and the officer attempted to detain the defendant, and the defendant ran northbound, ran through an apartment complex. The officer drove through the complex and set up a perimeter and observed the defendant run out of the complex. The officer exited a marked patrol vehicle in full uniform, drew a duty weapon, and ordered the defendant to the ground. The defendant ignored the commands and continued running and was assisted to the ground by the officer. The defendant stated he ran due to being scared. The defendant evaded approximately 0.4 miles.
What was he doing wrong?
So there was a report of a possible firearm on campus, and the caller provided the name, and he was attempting to investigate that, and he was just trying to detain him to
They
investigate.
give the description of him.
They just gave the name, and then they
A name
ran
of-
that through arms, and they found a picture of that person.
So the caller gave the name of Mr. Newman.
Yes, Judge. Gave Mr. Newman's name. The officer ran that name and found a picture, and then observed him leaving the library and attempted to detain him. And then he ran.
There was also a current trespass notice for the defendant as well,
Yes, Judge.
From TSU.
from the arms or TSU.
Yes, Judge. They found for TSU through arms.
Mr. Newman, I'm going to find that there's probable cause to go forward with your case. Let's do this. I'm going to appoint you a lawyer today because there's several things that we need to look at. So do you mind reaching out to the MAC for Mr. Newman? Mr. Newman, assuming we go forward with the case, you're not to be in possession of any weapons. Do you understand? I'm
Yes,
making
sir.
that a condition of your bond.
Yes, sir.
If I find that you have any weapons, I'm going to revoke your bond. I'm going to put you in jail. That's just, all I want is my community to be safe. I'm not asking for much. You understand? Okay, I'm gonna have you sign a receipt, Victoria, then we'll have you take a seat in the jury box, sir, okay? Good morning, Mr. Elzey. It looks like you were charged with 2 cases. You were charged with criminal trespass. You're also charged with criminal mischief. You've worked out an agreement. They're offering you 48 days in jail with credit for the 16 that you've done on the criminal trespass. They're dismissing the other case.
Yes, Your Honor. Time served on the criminal trespass and dismissing criminal.
Is this how you understand it, sir?
Yes.
You need to understand also that this charge will go on your record. You're now facing a minimum of 30 days in jail for any new cases that you pick up. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. Like I said, you give up the right to appeal. So once you plead guilty, it stays on your record. Is this what you want to do? How do you plead? How do you plead to the offense, sir? Guilty. All right, I'm gonna find you guilty. I'll follow the agreement. Good luck to you, sir.
What about the enhancement?
Abandoned. Yeah. Is it true or, come up, Mr. Elzey. Is it true or untrue that you had a prior terroristic threat, sir?
I'm on my medication, so I missed my medication. I have trouble getting my medication. I was just,
Did you have a prior terroristic threat in the past? It looks like from August of this past year with us.
I don't remember any terroristic threat towards you guys or
No.
Just in general.
You had a case in this court that you took 57 days time on, and that was August 20th of 2024. Do you remember taking that plea bargain?
I believe I was in court before, but
That's all we need to know. That's it. Okay, all right. Thank you. Okay,
Judge, so we have had a number of discovery compliance hearings, 4 actually, about a witness, one of the sheriffs who wouldn't turn over his MDTs and his information. And the last one, I've been asking for the court to strike him as a witness, and Your Honor said granted that orally. But I filed a motion to memorialize that, and I saw the state's pretrial filings listing him as a witness. So that's why I just want to make sure that that's, you know.
He was listed in our expert witness notification or notice. I did not know of this ruling beforehand, so I can amend it to
Okay.
take him off of it.
okay.
And that's,
So you guys talk about it, so if you can let her know everything that transpires so that she's in the know. This is your case?
Yes, Judge.
Okay, great.
I'm not saying obviously Ms. Watson's new on it, she was not
Sure.
privy to that, but it made me realize I'd like to memorialize that.
Yeah, absolutely. I'm okay.
I think that motion in your queue.
Yeah. So let's do this, though. Before I sign it, I want you to take a look over it, see if you have any objections,
Okay.
and then just let me know. If you don't, I'll sign.
I do assume that the state would probably object to the substance of it is striking a witness.
Well, I mean, if there's anything else in there, because,
Yes.
okay. All right,
I'm repushing on this motion to strike witness testimony, I think is what.
okay.
State has no objection. I spoke with Morgan. We haven't been able to find this witness anyways.
So it's just, okay. That's
Yeah, sure.
crazy, right?
Yeah.
I've never run across this before, so something must be up. Something's not right,
That is Mr. Riley.
Yep.
Riley, last time he was here, Your Honor asked him to
Respond.
do some employment, which he's done, I've got proof of that.
Okay,
Schooling, I spoke to his mother and his aunt, and the issue there is, he doesn't like the school he's zoned to, it's not a great, fit for him. And so he's trying to get with the aunt, and there's just some logistical issues, but I spoke to both the individuals, and I mean, he's making good faith efforts to do it, he's just, has not yet.
is he here?
Yeah, he's here.
Okay, Ridley, come up. Thank you so much for coming. It's great. So what's going on with Mr. Ridley now?
I had the excellence in school, like the holiday work together, but he's looking for a job. And I'm trying to get in with my two staffs.
So you're not doing anything now? You stay at home and do nothing?
I was. I got put like 3-4 applications in.
School is more important, Mr. Ridley. You need to get your education, man. You need a high school diploma. At worst comes to worst, we can give you paperwork so you can do the schooling at home and get your GED online at a minimum, and we can give it to you for free. But I mean, you're at home you're not working, you're not going to school, you're doing nothing to make life better for yourself. Life doesn't get easier the older you get. It gets more difficult. If you don't have a job, if you don't have an education, you will end up nowhere. And life sucks without money. Trust me. Do you understand? Okay. Do you mind giving them the paperwork, please? We need to be somewhere, Mr. Ridley. I'm going to give you another couple weeks, 2.5 weeks. At the minimum, be enrolled to start working on your GED. Do you understand? I'm also going to drug test you. I'm not going to let you there's no smoking weed, none of this. Do you understand? If I find that you're using, I'm going to revoke your bond. I'm going to keep you. Do you understand? All right.
Mr. Judge, we would request the complainant has made contact with the DA's office and let her thoughts be known on the case in a RIP call. And so we request that the no contact be just brought down to no threatening, harassing.
Who is it?
It's girlfriend situation, Judge. And I spoke to DV about it. He reviewed it and said he was going to leave notes that they had no opposition to that.
Yeah, or even something else.
And yes, that is correct. The RIP does say no conduct, so no threatening, harassing would be fine.
Okay. I will amend your bond condition, Mr. Ridley, to have no lasting contact with the complaining witness in this case. You're not to be in possession of any weapons. Do you understand? You need to start working on your education. Life doesn't get easier. Do you understand?
Sorry.
That's my main concern. You graduate, you get your GED, we're all going to be jumping up and down because that's what you need. Without a high school diploma, you will literally make pennies when everybody else is making dollars. Do you understand? I'm bringing you back in 2 weeks. If you've done nothing, it's not going to go well. Do you understand?
Yes, sir.
Okay, see you in 2 weeks. All right. Hi, Ricardo.
Hey, Judge, good to see you. How'd you fare?
Wonderful. You know,
Yeah?
he doesn't like snow. Kids just, they dig it, right?
Yeah, it's a big deal for them.
Yes. Absolutely. Do you have children?
I have the 1-year-old and the 21-year-old.
Oh, that's a huge, I mean, my goodness.
The question I always get is it the same mother? That's the question there.
I wasn't gonna happen.
I didn't think of it like that, but yeah, that's a good point.
Okay, so tell me what's going on.
Dave's asking for extension.
So this one for Sims, we're asking for an extension from Mississippi for a probation violation for malicious mischief. Obviously, due to Winter Storm Enzo, they're requesting extension because the airports were literally closed.
Get ready, we're gonna get so many of these, you know?
Oh,
Let's get ready.
yeah, they're
There's-
coming.
And so this one out to the 27th, the 28th, they'll pick up on the 27th, but because even with when they were originally supposed to come on the 21st, it wrapped around the weekend. That's why we're entering the pre-signed waiver. Ricardo is opposed, which is why I'm entering it.
Okay, I mean, I have to, you know, circumstances beyond, I mean, an act of God, right? As they say.
Of course, I gotta be opposed. I gotta fight for my client. His expectation was to get out at a certain day, through no fault of he's gotta be here an extra 7 days, looks like. He doesn't control the weather. Nobody does.
Is it 7?
It's because the original pickup date was the 21st. Well, so the 21st, and then the court reset date would be the 28th. They're looking to pick them up on the 27th.
It's getting a little bit less than a week. Understand that there is an act of God, right? It just completely closed everything. You get just one kernel of snow, the entire city shuts down. So I'm going to grant them an extension. You're not going to get another one.
I have to ask Judge.
So understand, Mr. Kim, that I don't,
They had like 13 days before the snow. That's not sure. Why they didn't come in?
Well, I can't answer that. I mean, that's something.
Oh, yeah.
Judge, I would ask, would you consider giving him a bond so he could go turn himself in and not have to wait 7 days? That's what we said.
For the pre-signed
There's
waiver.
a pre-signed waiver. I
Pre-signed
can't
waiver,
get
he's not
along.
allowed.
Understood.
Yeah, I mean, you got to understand, when you get on probation or when you get on parole in another state, you sign conditions. One of those conditions is that if you ever take off and you become a fugitive, you waive extradition. It's a pre-signed waiver. You have already waived by virtue of signing. You need to read every single thing that when you sign it, all the little print, because even if I wanted to give you a bond, I can't, because you have already waived by signing that document.
Judge, is for some reason they're gonna make it by this deadline, will he be getting out?
That's a great question. Mr. Kim?
Unfortunately, with the full, I got to look at the original waiver date. So it's 5th. So statutorily, they have until February 4th, 2025. So strictly speaking, for the pre-signed waiver, he's not allowed to. But this is one where they've already confirmed they're coming on the 27th. So I think it will be a distinction without a difference because they've already scheduled for him to come on the 27th, unless we get another once in a lifetime storm.
So we're gonna give him until the 4th is what I'm hearing?
Well,
No.
the recess is gonna be 28th.
28th.
That's that one.
They already indicated they're coming on the 27th.
I mean, act of God.
I don't see anything happening between now and then. Otherwise, the news would be just going nuts, you know?
Understood. All right,
Yeah.
well,
I mean, should something happen, we'll cross that bridge when we get there.
we're back up here.
They've said that they're going to come get you absolutely on the 27th. I don't know what time, but on that
I'll
day.
confirm with them that we approached and then submit the order, triple check today that that is still the confirmed date, because obviously we've had ones in the past where we confirmed too late and they had to move it. So I'm going to triple check today.
And he'll let you know.
I'll talk to them.
Okay.
Thank you, Judge.
What's up some more, Mr. Lopez?
Okay. Oh, I'm sorry. Did you have something else?
We did have one more, Judge.
Sorry, Mr. Saldana.
I don't know.
So this one, we're state's approaching off docket. May I give you the case number? 254-6960. It's a failure to appear for a burglary in the 3rd degree out of Oklahoma. And this is one where the court previously denied bond, and then when Judge Jackson subbed in, she also denied bond. This one, they're requesting an off-docket reset, but only for the maximum 3 days. And again, it's because the airports were closed down. They're able to do such a quick turnaround. But it would be because he had a Brazoria hold, it extended it out from the 14th, and then an off-docket reset to the 27th. So we're only requesting a reset from the 27th to the 30th.
Okay.
So they can pick up on the 29th.
I'd be opposed, Judge.
I know.
Okay, understood.
Thank you, Judge.
All right, thank you, Judge.
You are charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 3rd, 2025, the officer was dispatched to a disturbance at a residence in Harris County, Texas. Upon arrival, the officer met with the complainant, who knew the defendant as his sister-in-law. The complainant stated the defendant came to his residence shortly after a verbal dispute with his child's mother, and the defendant arrived and told the defendant told the complainant to come outside and meet with her boyfriend. When the complainant stepped outside, he was assaulted by the defendant by a closed fist to the back of the head. The complainant stated the defendant continued to strike him in the back of the head before he began stumbling down the stairs. The complainant was then assaulted by an unidentified black male while still being assaulted by the defendant and the defendant's sister. The defendant was gone on arrival, but was contacted via a public service by the officer and was ordered to return to the location.
Did the other person get arrested as well?
It appears there is a connected case, Your Honor.
The sister was also arrested.
So we have 3 co-defendants or
No,
2
just
co-defendants?
Yeah, just the sister, Your Honor.
Do you know of alcohol or any kind of,
There's no allegations, Your Honor.
see that she's on probation as well. Ms. Fair, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you not to be in possession of weapons, not to have contact with the complaining witness in this case, and not to be in contact with any of the co-defendants. Do you understand? Yes? Okay, if I find that you violate these conditions, I'm going to revoke your bond. I'm going to put you in jail. I'm going to protect my community at all costs. You understand, ma'am? Do you need a lawyer, ma'am? Okay. Ms. Fair, I need you to fill out an application for me. I'll provide you a lawyer after that. Don't violate these conditions. Do you understand, ma'am? Okay. Please, we'll have you sign a reset. You'll get with Fleischer for your bond conditions, and then we'll have you fill out an application.
I spoke with the complainant and
Ma'am, hold on. Come back up.
he's no longer living, he still has the lease to the residents of the 1180 Grant Road, but he's not living there anymore because the co-defendant lives there. He's actually living at his sister's residence, so if we could get a restriction, like a
Sure, just provide it to Felicia so she knows, and then we'll put that in the order as well that she's not to go to this location.
yeah, judge.
Okay, ma'am, please. Good morning, sir. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. So this is the one that we were talking about the other day, right? Where it looks like initially a magistrate found no PC, right? But then we have a refile the next day. Will you go ahead and read PC? You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer met with a complainant who stated that the defendant is her ex-husband, and the complainant advised that on August 25th, 2024, the defendant was at her residence regarding a visitation. As the two children went into the home, the complainant told the defendant to leave. The defendant then pushed his way into the home and pushed the complainant against the wall, causing pain. The officer observed surveillance footage showing the defendant push and strike the complainant in the upper chest area.
Oh, there's a strike.
Yes, Judge.
Okay. Mr. Reichert, I'm going to find that there's probable cause to go forward with your case. A protective order has been issued in this case. Get to know it. If you violate the protective order, the state can and probably will file a violation protective order against you. It's one of the worst cases you can pick up. You're not to have contact with this person and not to go where she lives or where she works. Do you understand? No. I can give you a lawyer.
Sir?
I can give you a lawyer if you'd like.
Yes, sir.
Talk to the lawyer, and the lawyer can come up and talk to me. I just don't want you to say anything. Believe it or not, I'm trying to help you because I've got a bunch of DAs here. Whatever you say, they're going to try to use it against you. All right? Do you need a lawyer?
Yes, sir.
All right. I'm going to have you sign a reset of Victoria. We'll have you skip in the jury box. If you can file the conditions, no contact, no weapons, please.
Yes, Judge.
Have you signed the conditions, and then we'll provide your lawyer here momentarily. Okay? Please, sir. Morning, Ms. Rossio. Ma'am, you're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Hold on. All right, Ms. Rossio, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On August 9th, 2024, the officer observed a silver Nissan with an expired registration, and a traffic stop was initiated. The officer observed a strong odor of marijuana from the vehicle and observed marijuana in the back seat in plain view. A PC search was conducted, and the driver, Mr. Smoots, was detained. The female passenger began to act very irate and yelled at the officer. The officers told her to back up and stop interfering multiple times, and she refused multiple commands. The officers attempted to place her into handcuffs, and she began to walk away and pull away from officers. The officer had to assist her to the ground, and she was identified with a driver's license.
Ms. Rossio, I'm going to find that there's probable cause to go forward with your case. The only condition I'm placing on you is not to have contact with the co-defendant in this case. You understand? Sorry? Do you have a lawyer? Do you want a lawyer? Okay, we can provide you one today, but talk to the lawyer. The lawyer can answer any questions that you have. I don't want to answer anything now because whatever you say, they can use it against you. Just the only thing I'm asking you to do is don't pick up any new cases. Don't have contact with the co-defendant in this case. Mr. Smoots, do you understand? All right, can you file those conditions for me, please? We'll have you sign a receipt, Victoria, and then we'll have you take your seat in the jury box. We'll get all the documents ready for you. Good morning, sir. Sir, you were charged with driving while intoxicated.
From Cuba, came via the ocean on makeshift craft of sorts.
Mr. Espinoza Perez, I don't care. It doesn't matter. The only thing that matters is public safety. If you're going to endanger my public, then I'm going to bring the pain to you.
El dolor a usted.
If you have to go to jail
Tiene que ir a
for
una
one reason or the other, and you're not here with proper documentation,
propiedad.
because I don't know, you could be the Queen of England for all I know. Immigration will put a detainer on you. You will sit in jail until immigration is going to do whatever they're going to do. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand?
Yes.
If you get pulled over, first thing an officer does is they look up your criminal history. If they see prior DWIs and they come up to you and say, smell alcohol, it's probably not going to go well. So from now forth, I would never, even if you had a sip of alcohol, get into a car. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never take this off. Do you understand? This is what you want to do.
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I will find you guilty. I want to send you to the agreement. Let me make one more thing clear, Mr. Espinoza. There is a $3,000 surcharge on this type of case. You pick up a DWI second, it's a $6,000 surcharge on your case that you can probably end up paying. I will waive it now, but understand, if you continue to put other people's lives in danger, it's not going to go well for you. Good luck, sir.
At approximately 6 p.m., officers initiated a reverse prostitution investigation. Undercover officers saw a defendant parked near where she was standing. Defendant rolled down his driver's side window. Officers approached the defendant and had a conversation sexual in nature. Defendant agreed to engage in sexual intercourse with the officer in exchange for $100. Defendant and officer arranged to meet at a motel. Defendant started driving in the direction of the motel. Defendant was then stopped and identified by marked units. During this, officers located a loaded firearm behind the front passenger seat.
During the search incident, sorry.
So it would have been
My argument is that the possession of the gun was not while he was engaged in this alleged criminal activity.
And we would understand where he's coming from, Your Honor. However, he did have the loaded firearm behind the front passenger seat, and this was search incident to arrest. So that's where we would be at.
We have the unusual circumstance here of my client is an aircraft mechanic. He works over at IAH. As a result of the gun case, not the solicitation case, the gun case, he lost his job. He can get it back because he's a member of the union. But the gun case is the only problem because he was charged with the gun. He lost his job. Now, I assume we're going to be able to work out the solicitation case through the stand.
I mean, I'm sure this would probably work out in conjunction as well, you know? I mean, it's,
So, but in the meantime, he can't work. So,
let me read the statute. Hold on. So I'm looking at 46.02. Unlawful carrying of a weapon. A person commits an offense if the person, one, intentionally, knowingly, or recklessly carries on or about his or her person a handgun at the time of the offense. So is this at the time of the offense? Right? I guess there lies the question.
He was proceeding to the motel where the incident, the
that they agreed to would occur. So during the process,
So, because, I mean, the offense is committed when? When the actually agreement took place.
Requires the way the charge reads, it requires, the offense is complete at the time that an agreement
Is reached.
made. So
The agreement is made at the time, allegedly, when they're stopped. They had the wherewithal, if they wanted to, arrest him at that time, where subject to arrest at that time, they could have made the charge, so to speak, right? But they decided to wait.
Well, Your Honor, if I may, the statute reads they had honor about his person while committing criminal activity, and the firearm was in the vehicle while the offer was being made. It was just on the way to the hotel or the motel is when they stopped him and search incident to arrest for that solicitation. That's when they found the firearm. But the firearm was on or about the defendant's person while he was engaged in the offer for the solicitation.
And also, if I may, Judge, I would also say it would make sense for safety procedures for them to make the arrest while he was on the way to the motel so that they could have followed him and it wasn't just that undercover officer there at the scene of making the arrest.
Now, I don't know, because they could have arrested him at the time, right on the spot. I don't know why they would try to bolster the case, I guess, by saying that there's more evidence of guilt by actually going to the motel. I mean, theoretically, they could have arrested at the time that the agreement is made, right? It's a contract.
Judge, I think we would just stick to the way the statute is worded is while engaged and the firearm was there. And they could have arrested him earlier, but as Mackenzie knows, they do that routinely for safety purposes as well as perhaps, as you mentioned, they could have done it for further evidence as well, further investigation.
Prostitution cases I've seen is they arrest right on the spot, right then and there. They don't wait. I mean, the offense occurs right then and there.
And the offense did occur, and while the defendant was in the vehicle, that's when the offense occurred. He was in the vehicle when they made that agreement, and the firearm was in the vehicle. They found it right after they followed him to the motel. It was in the same transaction.
the offense was complete.
I agree with you. I'll find no problem. Okay. So they're going to dismiss the trespass. We go forward on the DWI second.
Yes, sir.
You are charged of driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. You know, you just heard what I said to this other gentleman here. Life doesn't get easier. It gets a lot more difficult the older you get. And when you start racking up convictions, all you're doing is you're making the life even just more difficult. If you have a drug and alcohol problem, there are ways to address it. But when you endanger other people's lives, you may end up digging a hole that's so deep you'll never crawl your ass out of it. And you'll be stuck like Chuck in custody for the next 40 years. It happens time and again. If you don't believe me, watch the news. Every single day, someone dies from a DWI in our county. Yesterday, a construction worker. Take an Uber. It's extremely easy. They make it so easy that all you literally have to do is push one button. Because I'm going to tell you now, with your history, if you ever get pulled over and an officer smells anything funky, you're going to go down. And this time, it's out of my hands. From now on, you're in felony court. You're 2 to 10 at the penitentiary. Even the faintest smell of alcohol. Do you understand, Mr. Jaggers?
Yes, sir.
Somehow we have to get through to you. Hopefully it doesn't take the fact that you sit there charged with a 5 to life case because you've done something that just can't get a clue. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported excluded from the country, denied naturalization under federal law, you give up the right to appeal. Once you plead guilty, these will go on your record. 1 and 1 are 2. 2 plus 1 is 3. A third, you're looking at 2 to 10 at the penitentiary. Do you understand?
So,
The rest of your life. What are you, 32 right now?
31.
31. You're gonna be driving for the next 40 years. How do you plead to the offense of second offense driving while intoxicated? I'm gonna find you guilty. I'm gonna sentence you to 330 days in jail. I'll give you credit for the 113 days that you've done. I am gonna suspend your license for 1 year. Do not drive until you get a license. What do you do for a living, Mr. Jaggers? How much money do you make a month?
There right now. I'm appointed to this case, Judge.
So you're working for free? What?
Yes.
I don't know. Well, why would we reward him? He was to obtain a device he just never did.
He doesn't have a vehicle, Your Honor. I was notified by pretrial yesterday that there was this BVR. Talked to Mr. Jaggers about it. He didn't have a vehicle, and by his account, I didn't have a vehicle. He didn't know what to do. But he's here today.
So you just do whatever you want? I mean, this continue to happen over and over and over. I mean,
He spent, better part of 4 months, 3 months in jail, awaiting resolution of this case. He has done that time, Your Honor. He's working now. I really believe that to help him get better, he needs to put this behind him and get started with a new phase of his life.
Mr. Jaggers, I'm going to waive the court costs and I'll waive the DPS fine and surcharge. Just take a damn Uber, man. It's not hard. One button on your phone. All this could be avoided by hitting one button on your phone. All right, good luck.
Thank you, Judge.
Good morning, Mr. Chavez. So you're charged with driving while intoxicated. You are facing up to 6 months in jail and/or a $2,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand, sir, that this charge will go on your record. It's going to be there for the rest of your life. When you plead guilty, you give up the right to appeal, meaning that you can never change this. Do you understand?
Yes, yes.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. Do you understand these rights that you're giving up?
Yes.
You also need to understand that there are no more proverbial slaps on the wrist. From now on, you are facing a minimum of 30 days in jail for any new cases that you pick up in here. And if you're not in this country with permission, you do anything short of more than 6 hours, you will get an ICE detainer. So if I were you, I would never, even if you've had a sip of alcohol, get into a car and drive. Do you understand?
Yes, I
How do you
understand.
plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will sentence you to 3 days in jail. I'll give you credit for the 2. I'm going to suspend your ability to drive for 90 days. Do not drive. Otherwise, you're going to be right back over here, sir. What does your client do for a living, sir? What does your client do for a living?
He does the carpentry work, labor work, the framing, that kind of thing. Home framing.
I'm asking this because there is a DPS surcharge that they usually tack on for around $3,000. I will waive this fee for you now, but I'm telling you on the DWI second, it's around a $6,000 surcharge on a DWI second. So get a clue. Do you understand?
Yeah.
You're allowed to make a mistake, but when you continue to make mistakes with you endanger other people's lives, there are serious consequences. Good luck, sir. All right, win. All right,
Well, then, there's a portable device, Judge, that you've been.
we'll take it off.
Thank you.
Let me express my extreme disappointment, Mr. Guevara Ortiz. You now stand charged with yet another DWI. On this one, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On January 19th, 2025, at 11:43 p.m., the officer was dispatched due to a concerned citizen following a possible intoxicated driver. The call was near Northborough in Houston County, Harris County, Texas. The officer arrived at a public place and observed the defendant, the driver, and sole occupant of the vehicle. And the witness stated the defendant was observed to have severe damage to the front passenger side, and he struggled to stay in its lane several times. The witness had eyes on the defendant until the officer arrived, and the officer made contact with the defendant, who advised that he had 3 Coronas and was coming from a gas station where he purchased the beers while driving home.
So drinking while?
No, Your Honor, there's no indication of that. He just purchased while driving home. And the officer observed glossy eyes, delayed responses, and a strong odor of an alcoholic beverage. The officer conducted standard field sobriety tests, HGN 6 out of 6. The defendant refused the walk and turn and one-leg stand due to the cold temperatures. The defendant was read the DIC and consented to parade. The results were 0.189 and 0.177.
Mr. Guevara Ortiz, I'm going to find that there's enough probable cause to go forward with your case, and I am now going to revoke your bond on your first case, and I'm going to set it at $10,001. You now also have an immigration detainer, so you will be stuck in there, I guess, until I need to know, counsel, if you guys are planning on trying to get him an immigration bond or not.
Your Honor, we don't represent him on the immigration case. It's my understanding from Mr. Breston that there's an effort to address that.
Okay. You're signing on for Mr. Breston now, right?
Yeah, I work for him. Yes, sir.
Got it. All right. Mr. Guevara Ortiz, I'm now ordering you to have an ankle monitor on your ankle, and I'm giving you a curfew of 7 p.m. to 7 a.m. I'm going to put a scram ankle monitor on you so I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor. I don't know if you're getting out of custody, but if you do get out of custody, these will be your bond conditions. You will have on one ankle, like I said, a scram monitor, so I know that you're not consuming alcohol. On your other, you will get a GPS monitor, so I know that you're abiding by curfew. Do you understand?
Yes.
Okay, so I guess we'll set you out for 30 days. Just keep us in the loop. If you are able to get an immigration bond, you must be here the next business day. If you fail to do so, I'm going to revoke both of your bonds and set them extremely high. Do you understand?
Yes.
Okay, all right.
Thank you, Your Honor.
Thank you, sir. Good morning, Mr. Perez Reyes.
Morning.
So you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 28 days in jail with credit for the 28 days that you've already done. Is this how you understand it?
Yes, sir.
Excuse me. This charge will go on your record. It's going to be there for the rest of your life. You need to understand that from now on, you're facing a minimum of 90 days in jail for cases like this that you pick up.
Yes.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this.
Yes, sir.
What you want to do?
Yes, sir.
How do you plead to your offense? How do you? I'm going to find you guilty. I will follow it. Good luck to you, sir. Thank you, Josh.
Because there was a couple of snow days and no excuse to.
Nah, I'm trying to look like you. I don't know if I can get it that long. I mean, I'm just the itchy. It's so itchy, man. I can't take it.
Promise. Now, if I shave, I don't realize my face is much smaller than I remember.
Yeah. Perhaps, like Captain Jack.
Yes. Good seeing you.
You too. Sorry to keep you waiting, ma'am. From now on, what I would do is next to your name, put interpreter so we know who you are. That way it'll make it a lot easier for us when you're trying to zoom on that we know who it is and the purpose.
Sure.
Okay?
Yes, because I was logged in, from 9:30 because they told me that you have to log in as soon as possible, but 9:30 to 11:30, nobody
That's okay.
joined.
Well, so from now on, make sure you put interpreter because I get a lot of people that try to log on
Oh,
and they
okay.
do very dubious things.
Sure.
Okay.
Sure. Yes.
All right. You are Azadi.
Yes.
You speak
Uh,
English.
Right.
What language do you speak?
Dari.
You speak Dari, ma'am, correct?
I speak Dari and Farsi, yes.
I have a translator here for you so that you can understand what happens.
Should I start to translate?
Shh. Will you be able to faithfully translate everything I say to this gentleman?
Yes, I do.
Okay. You were charged with assault, bodily injury.
شما در واقع به حمله مسلحانه به کسی حمله کردی، اونجوری متهم شدی که به کسی حمله کردی.
Do you understand how she's... Okay. You are facing up to a year in jail and or a $4,000 fine.
میگه 1 سال بعد زندان بری و $4,000 بعد جریمه پرداخت کنی.
We are going to do probable cause.
در واقع اینجا میخوان برای شما یه excuse me sir, I don't know exactly what does probable cause mean. Sorry about that.
We're going to determine whether there's enough evidence to go forward or not.
میگه در واقع میخوان شواهد رو بررسی بکنن که ببینن بعد چجوری در مورد مسئله شما تصمیم گیری بکنن.
You have the right to remain silent. Anything you say can or will be used against you.
میگه حق اینو داری که در واقع ساکت بمونی، هیچی نگی و هر چیزی که بگی میتونه علیه شما استفاده بشه.
If you cannot afford a lawyer will be appointed to represent you.
میگه اگه که توانایی در واقع هزینه پرداخت وکیل رو نداری، دادگاه برای شما یه وکیل انتخاب میکنه. یعنی میتونی ساکت بمونی و بگی من وکیل میخوام. وکیلت میتونه از تو دفاع بکنه.
I'm now going to have Alex, our local prosecutor, read what happened. So, go ahead.
میگه الان این در واقع اون کاراگاه مخصوصشون که کاراگاه مخصوص این کار هست برای شما میخونه که چه اتفاقی افتاده.
Okay, go slow.
Yes, Judge. On January 15th, 2025,
میگه در 15 ژانویه 2025
the officer is dispatched to a possible assault.
فهمیدن که شما به کسی حمله کردید.
The officer observed one student being assaulted by 2 other students.
میگه اون در واقع اون آفیسر اون مأمور دید که یکی از دانش آموزان به وسیله 2 دانش آموز دیگه مورد حمله و ضرب و شتم قرار داده شد.
The officer stepped in and grabbed the defendant and escorted him to the police office.
آفیسر اون مأمور پلیس در واقع وارد مداخله شد و اون کسی که صدمه دیده بود رو برد به پلیس، به دفتر پلیس.
Surveillance video showed the complainant speaking with the defendant in the cafeteria with other students.
میگه که اون ویدیویی رو که در واقع داشتن بازرسی می‌کردن که ببینن چه اتفاقی افتاد، توی این ویدیو دیدن که اون دانش آموز تو کافتریا داشت با اون 2 دانش آموز دیگه صحبت می‌کرد.
Students separated the defendant and the complainant after the defendant charged at the complainant.
میگه بقیه دانش آموزا اون کسی که مورد ضرب و جرح قرار داده شده بود و اون کسی که داشت ضرب و جرح می‌کرد رو در واقع جدا کردن از هم دیگه.
The defendant was being held back when a 15-year-old started punching the complainant.
میگه که اون دیفندنت اون کسی که مورد حمله قرار داده شده بود خودش رو کشید عقب وقتی که دید اون یکی دانش آموز در واقع
Excuse me.
لگد به حساب. Yes.
Ma'am, please don't talk. If you want to talk, you can go out.
Yes, Judge.
Did you just say the defendant was being held back?
Yes, and as I keep going, he breaks loose. So the defendant broke loose from the other students and joined the 15-year-old in the fight.
میگه اون کسی که مورد حمله و ضرب و شتم قرار داده شد خودش رو به عقب پرتاب کرد. Sorry, can you please repeat the second part of the sentence?
Yes, so the defendant joined the 15-year-old in the fight.
میگه اون کسی که مورد ضرب و شتم قرار داده شد در واقع به اون یکی دانش آموزی که 15 سال بود به اون ملحق شد.
The defendant punched the complainant multiple times.
میگه اون کسی که در واقع مورد ضرب و جرح قرار داده شد چند بار هی ضربه زد به اون یکی دانش آموز.
The complainant stated he felt pain after getting thrown on the ground.
Sorry, can you please repeat it one more time?
Yes, no problem. The complainant stated he felt pain from getting thrown on the ground.
اون کسی که در واقع مورد حمله قرار داده شد که در واقع شاکی بود میگه بدنش درد گرفت بعد از اینکه مورد اون ضرب و جرح و حمله قرار داده شد.
Who is the complaining witness? And where was this?
So the complaining witness is another student and it took place at a school.
قاضی میپرسه که اون شاهدی که در واقع داشته میدیده جریانات اون کی بوده و ایشون اون پروسیکیوتور دارن میگن که ایشون یه دانش آموز دیگه بود اونجا که در واقع صحنه رو دید که چه خبر شده.
Which school?
So I'm trying to find, Your Honor.
Wisdom High School, Judge.
Okay. Have you reached out to the complaining witness?
Yes, Judge. I did to reach out to the complaining witness. I have not heard back from him.
Okay, so I'm going to find probable cause exists to go forward with your case.
قاضی میگن که من در واقع میخوام حالا اون شواهد رو پیدا بکنم که ببینم که چجوری که این مسئله کیس شما رو جلو ببرم.
As a condition of your bond, I'm ordering you not to have contact with the complaining witness in this case.
میگه اگه بخوام در واقع برای شما یه ضمانت قرار بدم ازت قاضی خواهش میکنه که با این شاهدها با این شهودی که وجود دارن نباید در تماس باشی.
I'm also ordering you not to be in possession of any weapons.
و همچنین نباید هیچ نوع سلاحی با خودت داشته باشی، نباید هیچ سلاحی حمل بکنی.
If you violate any of these conditions, I will revoke your bond and put you in jail.
قاضی میگن که اگه از این چیزایی که من گفتم سرپیچی بکنی میری زندان.
Do you understand?
متوجه شدی؟
Would you like a court-appointed lawyer today?
دوست داری که در واقع دادگاه برای شما یه وکیل اختصاص بده، یه وکیل داشته باشی از طرف دادگاه؟ Yes, he does.
I will provide you one. My only other issue is whether to bar you from going back to the school or not.
قاضی میگن که برای یه لویر یک وکیل باید انتخاب میکنن، فقط مسئله مورد نظرشون اینه که نمیدونن باید اجازه بدن که تو برگردی به مدرسه یا نه.
I will have you speak to the lawyer and we will determine how to go forward.
قاضی میگن من با یک وکیل صحبت میکنم و از اونجا در واقع ببینیم که چجوری باید مسئله رو پیش ببریم.
Do you understand?
متوجه شدی؟
Okay. Okay, we will have you fill out an application. I will have you sign a receipt with Victoria, and then we'll go. I'll have you give it back to me, and I'll look and provide your lawyer today.
میگن یک چیز به نام اپلیکیشن به تو میدن، اونو باید پر بکنی، به یه خانومی هم بهت کمک میکنه، بعد اونو تحویل میدی و برای تو وکیل انتخاب میکنن.
Thank you so much for the help. I appreciate it.
Of course,
Okay.
thank you. You're welcome.
Yes, ma'am. You're free to go.
Thank you. Bye.
Mr. Azadi, it is a really terrible thing to have to live in fear. All someone wants to do there is get an education. And it's unacceptable that anyone has to live in fear wherever they go to school, wherever they work, whether they live at their house. I don't want to hear of any issues here. If I find that you become a problem while you are on bond, I will put you in jail. Do you understand? I don't want this other kid to live in fear. You understand? We've given you a lawyer. You must listen to Mr. Sims and he will take care of you. If he tells me that you're not listening and you're not responding to phone calls or text messages, I will issue a warrant for your arrest. Do you understand? Okay?
Thank
All
you,
right,
Judge.
goes with you.
Judge, he has 2 classes.
Sit down, please.
Oh, sorry. Judge, he has 2 classes with the complainant. And so what I told him that probably is the solution is he needs to go to the principal and say, I need to be moved out of those classes. You know, that's probably the best for everyone.
Okay.
I think you probably agree, Judge. Because you could try to have 2 people at opposite sides of the classroom, but it's pretty
I
difficult.
don't know. All I know is that I don't want any more issues and I don't want the kid to live in fear.
Right.
So I'm not asking for much, you know?
Okay.
So
Just tell him that he needs to talk to the principal about it. Okay, thank you, Judge. Really up for Mr. Richardson, Judge. Just gonna ask that paper team.
good morning, Mr. Richardson. So he has a total of 3 open cases, right?
Yes, Judge.
Mr. Richardson, you've got 3 open cases. You've got 2 counts of assault and 1 evading arrest. Looks like what's happening is you are pleading guilty to both assault cases and they're going to dismiss the evading. Is that how you understand it? The agreement that you guys have worked out is they're offering you 95 days in jail with credit for the 97 days that you've done. So it looks like you're done. When you get out of here, you have to understand that from now on, you will be facing a minimum of 90 days in jail. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you cannot change this. This is what you want to do? How do you plead to the offense as guilty or not guilty? I'm going to find you guilty. I'll follow the agreement. Good luck to you, sir. Your other case will be dismissed on motion of the state.
Feel pain at the time of the incident because she was fighting the defendant off of her. And that's what the full dim states. And the officer, based on training experience, saw the bruises on her and being grabbed and squeezed and came to the conclusion that it caused pain.
It could also be the exact, that what she said was, I was shaking and crying because I was fighting him. She's the one that says that.
I mean, I get it. Like at the time, you're in the stress of the excitement, so you're not feeling it. But then after.
That's not what she said, though, or that's not what
stress.
going on.
Your Honor, the key thing the officer observed were the bruises on the complainant's arm. He observed the bruising and then came to the conclusion based on that. And what she told him, she did say that the defendant squeezed her arm. And based on that, her crying, shaking, and the bruising, he came to the conclusion that she felt pain due to that being squeezed.
I mean, taken as a totality, is that not sufficient for probable cause purposes?
I don't know. You have a sworn document where she says one of the elements is missing. And then everything else that he's adding is not in that document.
To be more specific, she's saying she did not feel pain at the time of the incident since you were fighting. She didn't say she didn't ever feel pain. She said at the time since she was fighting the defendant off of her.
But the officer,
That's not in that.
But the officer never asked, hey, do you feel pain? Why
And
wouldn't you
the
ask?
officer never asked. He came to the conclusion based on totality.
Get it, but I don't know. I mean, I need to look up case law. I'm not sure. I don't know if that's enough. Because I mean, it's such a low standard for probable cause purposes, you know? I mean, I get that you're saying that it's not alleged the pain as an element, but taken as a totality.
I guess you're saying taking as a totality. I'm saying that's a lot of speculation about stuff that's not in the DIMS or in the affidavit. Like you're making all these connections state.
I'm making the officer made the connection. He said in the DIMS, due to my training experience, I know being grabbed and bruises being left on your body causes pain.
Right.
He made that connection.
You don't operate on hunches.
Right. And she's also stated that I was fighting him. So that could be because of her fighting.
I mean, here's the deal. Like if I find no PC, right? They may just re-indict it though.
That's fine.
You know?
That's their.
Kelsey,
Yes, sir.
did you see what's going on? So in this case here, the officer never asks her, do you feel pain? He assumes she does just because of bruising on her arm. And because I guess they're in the stress of the excitement. So at the time she doesn't feel pain, but after a while he assumes that she feels pain because of bruising on her arm.
And on body-worn camera, he never says, we don't know.
But I mean, this is a probable cause hearing. We haven't seen it. So he wants me to find no PC. If I do though, right.
Well, if there are visible injuries, we can go from there.
But he's saying that, you know, I mean, if it were like blood, like some kind of tearing of the skin, that's one thing. But bruising, is it possible to get a bruise without feeling pain?
Yeah, do it all the time. If you fall downstairs and you're embarrassed more than in pain, you might be crying or shaking because you're embarrassed or excited, but it's not because of you injuring yourself down the stairs.
But Your Honor, that also ignores that she did say the squeeze itself. He mentioning a fall, but in this case, we do have a specific statement about a squeeze.
She doesn't say that she's in pain because of the squeeze.
So if you lay it out in front of a jury, you would always have that statement saying at the time she didn't feel pain. Whatever you said contradicting that, it's fine, but it would not take away that statement that eliminates an element. So maybe a grand jury might find it different, but based on that DIMS, they have someone saying, I didn't feel pain. I think that's kind of like.
And Your Honor, I will say at the time, we don't have the full OR, so if you want to find no PC, we can revisit it. If we want to re-indict it, we can.
Okay, all right, I'll find no PC. Okay. You are Carlos Barrera. Sir, you're charged with terroristic threat. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On September 11th, 2024, in Harris County, Texas, an officer met with the complainant who advised that in the morning he received multiple phone calls from an unknown number beginning at 4:30 a.m., lasting through 4:50 a.m., in which the defendant called a total of 5 times. The complainant stated he did not answer the phone from previous knowledge that it was the defendant calling him to confront him. The complainant stated he left to work, and when he returned at approximately 4 p.m., he noticed multiple phone calls from an app-generated phone number that called him a total of 18 times. The complainant stated that on the 18th call, he answered the phone and let the defendant talk. The complainant was able to get a second cell phone and record the defendant stating, "I know where you stay at, you don't know where I am." The complainant stated he had sent a text message to the phone number that the defendant kept calling from, and said that he did not wish to have any contact with him and to leave the complainant alone and stop calling. The complainant stated that during the conversation over the phone with the defendant, before he was able to record the phone call, the defendant stated he was going to shoot the complainant in the legs so he could not work as an electrician. The complainant stated that the defendant is the complainant's current girlfriend's ex-boyfriend. The defendant is the complainant's current girlfriend's ex-boyfriend. The complainant told the officer that he believes the defendant is capable of carrying out his threat and the complainant is in fear for his life.
All right, Mr. Barrera, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have contact with this person. Do you understand? I'm also ordering you not to be in possession of any weapons. If I find that you violate any of these conditions, if you are a danger to my community, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand?
And Judge, given my conversation with the complainant that I had yesterday, the state would request a GPS monitor because he has continually gone to the residence since this incident and has made threatening comments towards the mother-in-law as well. And recently, as of a couple of days ago, I guess he left his wheelchair outside the home in order to make some sort of threat that he's been going near the residence.
So the threats are still continuing?
Yes.
Sir, I'm now putting a monitor on your ankle so I know that you're not going over there. You're not to go within 1,000 feet of where they live or where they work. Do you understand? Hold on. I don't want you to say anything. I will give you a lawyer today. You can talk to the lawyer, but understand my only concern is community safety. That's all I care about in this life. You know, we take things step by step. Let me do this. I'm going to give you a lawyer. I'll let you talk to the lawyer. I got a bunch of DAs here. Whatever you say, they're going to use it against you. Let me give you a lawyer. We'll go from there. But at this, don't go where they live. Don't go where they work. Don't accidentally bump into them. Do you understand? So for now, I am going to put a GPS monitor so we would know where you are. And you're not to go anywhere where they live or work. I'm going to have you now sign a receipt of Victoria. After that, we'll just have you wait for the lawyer that we get and we'll go from there. Do not leave until you sign our bond conditions. Otherwise, I'm going to revoke your bond. Okay.
Good morning, Judge Fleischer. Questions to approach?
Of course.
Thank you, sir. Your Honor, I've been appointed on Mr. Barrera.
Okay.
Barrera. Your Honor, it was brought to my attention that he's being required to have a monitor, home monitoring. And we would ask, Your Honor, that that condition be relieved, if the court would consider that.
The deal is, the reason that they said this was, and normally I don't put something on the first setting unless we have some kind of evidence showing that it's a continued harassment type situation. And we have that here. They're saying that, because I think she spoke to
The complainant, Your Honor.
the complainant, and the complainant is saying that he's continuing to harass, continuing to threat, leaving his, so will you let him know exactly?
Yes, counsel. So he's continuing to harass the complainant as well as he left his wheelchair at the complainant's residence by his mom, by the girlfriend's mom's car. We don't know why, but he was continuing to go to the residence of the complainant.
Continuing to call, text message, come up, sir. The deal is this, is that life is way too short. Life is way too short to make a decision where you make it or you've dug yourself a hole so deep that you'll never get out of. There are plenty of other fish in the sea, and it's time at times to just move on. Cut your losses, move on, because life's just way too short, There are other people out there, and as long as I know that we don't have any more issues in the future, I'm willing to take it off. But at this point, I got to know that it's going to stop, right? I'm not going to take your word for it that it's just going to stop. I need more than that. So that's why I put this monitor on you. After some time, if I know that I can trust you, then perhaps we can amend the conditions to take it off. But at this point, all I have is that you've picked up a criminal case. They're alleging that it's continuing to happen, and I want it to stop. Not I want it. It's going to stop one way or the other. I told you, life is too short. Move on. That's all that needs to happen. Do you understand?
But that I got shot.
Okay. So you've got a lawyer, right? My only concern is that you don't have any contact with these people and you don't go where they work. The past, I get it, it's the past. I get that you guys have bad blood. All I want to do is I want to prevent further bloodshed. I don't want any more bad blood. That's all I'm asking. I'm not asking for something unreasonable. But what we can do, after some time, I'll have them reach out, and if there are no issues, I can take it off. Do you understand? All right, I'm not asking for much. Just move on. It's just like I said, people here in life, in the jail, are there because they have no self-control. They just wig out. They do stuff without thinking, and then they make some kind of decision where they're looking at 40 to 50 years. Don't. It's not worth it, Okay. All right. So after some time, come back. Good. We'll take it off.
Thank you.
Okay. Good morning, Mr. Foster.
Mr. Coleman, Jeroy Coleman.
Got it. I didn't realize this too. All right. Good morning, Mr. Coleman. Mr. Coleman, you're charged with failure to identify oneself to a peace officer while being a fugitive from justice. That kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 15 days in jail with credit for the 5 days that you've done. It also looks like you have a second case that they're going to dismiss once you plead guilty to this offense. Is that how you understand the agreement? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. This will go on your record. You also need to understand that from now on, you're facing a minimum of 90 days in jail. Do you understand?
Yes, sir.
Your case is 1,864 days old. I will tell you that when you show up to court, good things happen. we don't ask for much. But when you continue to just take off, it makes things a whole hell of a lot worse. You got a great lawyer. All you got to do is listen. Things will all, things go right. How do you plead to the offense of failure to identify oneself? I'm going to find you guilty and we'll sentence you to the 15 days in jail. I will give you credit for the 5 days that you've done. I'm going to roll your court costs so you don't owe anything, and your other case will be dismissed on motion of the state. Good luck to you, sir. Good morning, Mr. Foster.
How you doing?
How are you?
Okay.
Mr. Foster, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You worked out an agreement. They're offering you 18 days in jail with credit for 18 days. Done today.
Okay.
Get out today. From now on, it's minimum 30 days in jail.
Okay.
If you go back to this place, it's not going to go well. Do you
I
understand?
ain't going back in now.
Don't go back, because otherwise you're going to come right back here.
I ain't going back in now.
You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. You're saying you don't want a trial. You give up the right to appeal. So once you plead guilty, naturalization. How do you plead to the trespass? Guilty or not guilty?
I'm guilty.
I'll find you guilty, sentence you to the agreement, 18 days in jail with credit for the 18, enhanced abandon. Good luck to you, sir. The lawyer's asking me to take you off the random callings. If I do, you have to understand you're still not allowed to use alcohol, illegal substances. You understand?
Yes, sir.
If I find that you do, I'm going to, revoke your bond and put you in. We don't want you to do that.
There's no priority, Judge.
Okay. I assuming that we haven't had any issues, just check with Felicia. If everything's been okay, then we'll take her off the randoms for now. Yeah. Okay. All right. Good morning, Mr. Marquez. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 17, 2025, the officer was dispatched to an assault. Upon arrival, the officer met with the complainant, who stated she and the defendant have been in a dating relationship for 11 months. The complainant then stated the defendant had been continuously assaulting her, and she showed surveillance video of the incident to the officers. The officers observed the defendant grab the complainant by the hair and strike her several times in the face with a boxing glove. The officer also observed the defendant get on top of the complainant and pin her down, striking her in the face, and the complainant advised she felt pain from all the strikes. The officer observed the complainant to have visible abrasions on her left shoulder and bicep, along with redness on her face.
He just had an assault that was dismissed in October of this past year.
Yes.
Is this the same complaining witness? Okay. Mr. Marquez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with this person whatsoever. I'm issuing what's called a magistrate's order for emergency protection, which is a court order that identifies Ms. Rubio as a protected individual. You're not to commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code. Is this a stalking statute? You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Melbourne Street place. Do you understand?
Yes, sir.
I want you to understand that I'm going to protect every single person in this county by all means necessary. You endanger my public, it's not going to go well for you. Felicia, I want to make sure that he's not consuming alcohol or drugs. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, make your bond very high. Do you understand?
Yes, Judge, the MOC was signed last Friday.
Okay. So it looks like a protective order has been issued. I would get to know it, because if you violate this protective order, the state can and will file a violation protective order that is a capital murder of misdemeanor. Do you understand, sir?
Judge, the magistrate also did order a GPS device that was,
Yep.
installed prior.
I'm okay with that.
I have it on, sir.
Did you want do you need a lawyer, sir? Okay, so you don't want a court-appointed lawyer then? Okay, I'm gonna have you sign a reset. After that, we'll get with Felicia for your bond condition. After that, you're free to go. Don't violate these conditions, Mr. Marquez. It's not gonna go well for you. Do you understand? Okay, come on. Good morning, Mr. Saavedra. Sir, you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
One moment, Your Honor, it's loading. Okay. On January 15, 2025, the officer was conducting surveillance in the Greenpoint area, and the officer was in an unmarked vehicle in an apartment complex and observed 18-year-old defendant join up with two other males, co-defendants. He had already witnessed using a firearm. The three males walked around the apartment complex together, and the officer witnessed the defendant being given the firearm and wave it around. The two other males encouraged the defendant to shoot the gun, and the officer did not see the defendant fire the weapon, and the officer maintained visual until the officers were able to detain all three defendants at a nearby gas station. The gun was found in the co-defendant's waistband, and all three individuals were placed in custody.
Mr. Saavedra, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of any weapons. Do you understand? I'm also ordering you as a condition of your bond not to be in contact with any. Did anyone else get arrested in this case? Or is it here? It's just him. I'm ordering you not to consume alcohol or illegal drugs. I'm sending you for a test right now. You're to come back. If you fail the test, if you fail to come back, I'm going to issue a warrant for your arrest. Do you understand?
Right, there's a co-defendant in court 4.
That's the
cause number is 2547734.
I'm going to send it? Okay, so let's just do this for now. Go ahead, take a seat for me. We're going to transfer your case to the other court because that's where it belongs. Okay, please.
Stephanie's coming down now. She decided to charge FSRA.
Right.
We just got the bonds walked through and we're back here now.
So did you get a bond set?
Yes, sir.
What?
10. The 2.
Oh, I see. Okay, right. Do you have a bonding company coming?
Sir, yeah, everything's already filled out. They're actually, he's coming down here now to walk them over.
Okay, so I'm going to release him to the bonding company. Okay, that way he can go post the bond.
Sorry, we were here earlier.
It's okay, but I wanted to make sure. I didn't know if they had taken him into custody or not. And I mean, normally when a felony warrant pops, we take him. And so, I mean, I don't know if he's going to have a problem with the new deputy. Oh, so who are you having coming from what bonding company? Is it Burns?
No, sir.
Someone else? Okay.
American bail bond.
He has a felony warrant because they filed a felony case just now, but he has a bonding company guy coming to take him to go do a walkthrough. So I was going to allow it when the bonding company comes. Okay, it's someone else. Yeah. Okay. So just take a seat for me in the jury box, and then when they come, we'll release them to you, Mr. Okay.
We have them on docket as well. I think Stephanie's on her way down right now.
There's still my elevator. As Bond said, I was just going to allow him to go do a walkthrough.
Yeah, we're all set there, no, absolutely.
Okay. Did they do any conditions or anything upstairs or no?
Conditions pretty much parallel what we had down here. No driving without an interlock, no drugs, no alcohol, no contact with the complainant's family, so.
Okay, great. I think we're good. Just take a seat for me in the jury box, and then when they come, we'll release you.
Morning, Your Honor.
Hey, how are you?
Doing great, thank you. Yes, sir.
Yeah.
Mr. I apologize. Mr. Sarmiento?
With an S?
Yes.
Sarmiento. Coming up. Sir, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 13th, 2024, the officer observed the defendant's vehicle traveling at a high rate of speed without a front license plate. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle. The officer observed the firearm in the passenger side door, and the officer asked the defendant to step out. The officer observed a firearm in the driver's side door and both firearms were unholstered. The officer asked the defendant for consent to search the vehicle, and the defendant agreed. The officer searched the vehicle within hand's reach of the defendant, and the officer observed a Ziploc bag in the glove compartment with a $20 bill and what appeared to be small baggies with a white powdery substance inside, believed to be cocaine based on training experience. The weight was 3.77 grams.
Okay, sir, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of any weapons. Do not pick up any new cases. Otherwise, I'm going to put you in jail. I don't know what your immigration status is, but if you go to jail and you spend any kind of time there, immigration, and you're not here with proper documentation, immigration will put a detainer on you. You will be stuck like Chuck in there until this case is over with and then shipped off to immigration. So beware what you do. I don't know what your status is, but if you're not here with permission, be good. You have a lawyer because you have one that will waive your appearance, but it is your responsibility to stay in touch with him. You pick up a new case, you endanger my community. It's not going to go well for you. Do you understand?
Yes.
We'll have you sign a resolutoria. We will have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. Thank you.
Thank you, Your Honor.
Morning, Mr. Paredes. You were charged with tampering with the government record with intent to make it genuine? Is that right?
I'm sorry. Say it one more time, Judge. I missed what you said.
You're charged with tampering with the government record. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 16th, 2025, the officer observed the defendant's vehicle with a paper license plate on North Freeway, East Service Road. The officer ran the license plate, and the license plate came back with no record. The officer observed the license plate was a copy and did not have required security features. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle. The defendant stated he received the license plate from the person who sold him the truck, that he receives a new license plate whenever he makes payments, and that he thought that was legal. The defendant stated he did not have insurance on the vehicle, and the officer ran the VIN and discovered the motor vehicle to be salvaged. The officer also found the vehicle has never been registered and had never had a state inspection. The defendant provided a dealer tag receipt for the license plate, listing him as a purchaser.
So he tried to purchase in good faith, Judge. He just, I don't see how there's any criminal intent.
But he's making payments and he gets a new license plate every time he gets a payment.
That's what the officer says. He was saying.
Well, right. But I mean,
Right.
Marcos, I see what you're saying because he's charged with tampering, right? To tamper, you must, I know, let's pull the code.
Right.
Because I mean, do you have to make a willing,
But you negligently or recklessly.
an alteration, so to speak, you know? Let's see. A person commits, if he knowingly makes a false entry in or false alteration of a government record, makes, presents, or uses any record, document, or thing with knowledge of its falsity with intent that it be taken as a genuine government record.
Your Honor,
I think that is what they're probably relying on in this case.
if I may, as the information alleges, it's subsection 6 where it possesses a governmental record with knowledge that it was obtained unlawfully. So,
Well, he doesn't know it was obtained unlawfully, even from.
Well, hold on. That's your burden, right?
yes, Judge, and in this case, we would show that reasonable certainty by his obtaining it every time he makes a new purchase and obtaining it from the person who obtained the vehicle rather than from the government. So it would be through that.
When I go buy a new car, though, they give me a tag. You know what I mean? So at some point, yes, you're supposed to get something like a license plate from, I guess, a state, you know, from the state authority, right? They give you the license plate, but here,
They give you the paper plate and you assume that they're going to do all the paperwork behind the scenes. They send it to the government, to the state agency. Then the state agency sends you the metal plates.
If this had been like maybe a month or two that he'd purchased it, perhaps. But if we're talking that he's had this car for like a year, then I don't think that's reasonable. I don't think that's a reasonable argument to make. So,
And I don't know how long.
this car purchase.
Let me see, Your Honor. So the only thing in regard to the status of the vehicle is the officer only found that it was a salvaged vehicle, and he lists the date of loss as May 29th, 2020. So I don't know if that's when the defendant obtained it, or that's just.
No, that's just when it was salvaged at that
Yeah, so
time.
that's
So
the
at
only-
that point, you can't even drive the car because it's salvaged, right?
Right, and
It's a
that's
salvage
the
title,
date-
but
date that the officer provides. So, and so with information we
you have a
have,
copy of the tag?
let me see. So the buyer's tag lists an expiration date of February 5th, 2025, and lists the vehicle of the 2007 Chevrolet, and it doesn't list.
It should say like a date of purchase, right? Why don't we do this? Look,
So it says it expires February 5th, and this happened on January 16th, and I just asked him when he bought it. He said it was about a month and a half ago, and I said, how many license, how many?
let's do this. Show me. Let me give you more time. Let me just do a little bit more diligence.
Okay.
All right. We'll come back, but let me burn through all this because I didn't think it was going to take this much time. But we'll revisit. Okay.
Yes, yes.
Don't listen.
Maybe we approach. So apparently I spoke with William about this case, and he, on the paper plate, which you have not seen, took a picture of the QR code, and it does pull up as though.
So what do you guys think?
Honestly, Judge, I don't know enough about motor vehicle registration to know what this QR code means, but I do know that when I did the QR code, it did pull up something.
And it did say the created timestamp was December 7th, 2024.
Oh, we can show you both. You like this one?
So wait. The paper plate has a QR code?
It has a QR code apparently on the corner, and when scanned, it gave the date of December 7th, 2024 as the creation.
This is end February
5th, which is the expiration.
So the issue is because
of knowledge.
Did he have knowledge of its falsity?
Right.
Did he, or did he? Because it's a specific intent crime, right?
And after Googling what a paper plate does look like, it looks exactly like it's supposed to. It's a little wrinkled, but that doesn't really.
All right, so I'm going to find no probable cause then. All right, guys. All right, so these are really, really old cases, huh?
These are super old, Judge. She had one attorney, I think it was during the pandemic, that we subbed in on, and then the other case as well, Your Honor. And it was a mix of a lot of things financially and on why he was kind of MIA.
Did you represent him before?
We were on the case, we just never got off. We were on the assault case.
Are you wanting to stay on or do you want to get off?
We're gonna stay on, Judge.
Okay.
You guess in a way rehired.
So, Mr. Montalongo, you're charged with two cases. You're charged with assault of a family member. You're also charged with terroristic threat. Both of those, you're facing up to a year in jail and or a $4,000 fine. I'm going to tell you now, you take off on me again, I'm going to make your bond so high you'll have hair falling out. Do you understand? As it stands now, your case is 1,289 days old on one. The other one is around another 2 years old as well. I'm assuming probable cause has been found already?
I would like to take up probable cause, Your Honor, on the terroristic threat one, if we can.
Okay, go for it.
Yes, Judge. On February 28th, 2023, the officer responded to a terroristic threat, and the complainant stated she is the sister of the defendant, and that prior to the day of the call, the defendant had been sending her threatening messages to her phone. The defendant sent a text saying, "I hope you take a punch to the fucking face. I'm gonna break your fucking face with my fist, bitch. I want to hear your bones break." The complainant stated the defendant has been verbally abusing her and has a history of assaulting their father.
Your Honor, I believe the key element they're missing in this probable cause for the terroristic threat is the imminency. There's nothing showing that this is imminent, it's about to happen, or is going to happen, or is a future event.
I mean, I'm going to.
I'm going to. It can be very vague, Your Honor. We don't know how long that's going to be. If it's like, hey, I'm coming over right now, or if he said that in person. I think the case law is pretty clear on the imminency on that. For example, like.
You're telling me there's case law that says I'm going to is not sufficient?
I have to look at the specific words of I'm going to, but it references a future event. So if it's in reference to a future event, it's not imminent, therefore it's not, it doesn't meet the requirement.
State response?
So what we have is that they had an argument the previous night, and that the morning of the incident, that's when he sent the text saying, I'm gonna break your face with my fist. So that would go towards, it doesn't really address the imminent issue, but it does address a future threat.
Montalongo.
Your Honor, I would agree with where you were going, the I'm going to, and just the overall tone of the message is implying imminent and will put a reasonable person in fear.
I think so as well. Mr. Montalongo, I'm going to find that there's probable cause to go forward with your case. I'm now issuing a magistrate's order for emergency protection that identifies the complaining witness in this case as a protected individual. You cannot communicate with this person in any manner. Phone calls, text messages, any way. You're not to threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? If I find that you violate this court order, I'm just going to put you in jail. Got to understand, I'm going to protect my public at all costs. I don't care who you are, what color, whatever. Do you understand? Now, I'm not waiving his appearance because the cases are super old. We got to figure out where we're going. So I'm going to give you guys one setting to figure out where we're going to go. Is discovery complete on both of these cases?
It appears that the RIP is missing on the terroristic threat, and on the assault, it's complete.
So, okay, so I'm going to give you 30 days. You must be back at that time to figure out what we're going to do. You must either accept a plea bargain from the state, or else I'm going to set your case for trial. You understand? Okay, so if you can please put offers on both of the cases, we'll see you back in 30 days. We'll go from there.
Understood, Judge. Thank you.
Mr. Cogdill.
Yes, sir.
Sir, you're charged with terroristic threat of a family or household member. That allegation kicks it up to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On March 1st, 2024, the officer is dispatched to a terroristic threat call in Harris County, Texas, and the complainant and the defendant have an on and off dating relationship. The defendant is also the father of the complainant's child. The complainant stated they got into a verbal argument and she recorded it. The officer listened to the recording, and the defendant stated he was going to beat her mom up and kick the door open and kill everyone in the house. The defendant also stated he has nothing to live for.
Mr. Cogdill, I'm going to find that there's probable cause to go forward with your case. Do we know if she wants to have contact with him or not?
Let me see if a RIP has been. Your Honor, there's been no contact made as of now.
Until I know that this person wants to have contact with you, I'm ordering you not to have contact with this person and not to be in possession of weapons. Do you understand? Just be good. It's not hard, you know. Would you like me to provide you a lawyer today?
Sir.
Okay. Would you mind filing no contact, no weapons? Yes. I'm going to give you a lawyer today. Just don't pick up any new cases. Be nice. That's all we're asking you to do. You know, really. I'm going to have you sign a receipt, Victoria. Let's see. I have an application on file already. So what I'll have you do is I'll just have you take a seat in the jury box. I'll wait to get your lawyer. I need you to sign these bond conditions as well, and then we'll go from there. All right? Please, sir. Good morning, sir. Sir, you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 16, 2025, the officers made contact with the complainant at a residence in Harris County, Texas, who stated the defendant came to the cul-de-sac on a dirt bike, began revving the engine, which got the complainant's attention, and the complainants began recording the incident on their cell phone. The officers reviewed a video from the cell phone showing the defendant sitting on a dirt bike, continuously revving the engines, and the complainants made contact with the defendant, and the verbal argument began. The defendant made the comment, "It's y'all asses. I know where you live. I got y'all." And the complainants feared for their lives, believing the defendant would return to cause them bodily injury. The defendant's residence is only 0.7 miles from the complainant's residence.
Judge, I think the facts are going to show this stems from a confrontation that the neighbors had with his children, and that there's more context to the alleged threat that explains that. However, my understanding is.
So are they next door neighbors?
They
So-
live in the same general neighborhood, but there's already a pretrial bond condition of no contact.
Got it.
And I've explained to Mr. Schreiber that staying away from them is good.
Just really, that's all we're asking you to do. You know, you've got a great lawyer. Listen to him. He'll take care of you. I am going to find that there's probable cause to go forward with the case. Just don't have any weapons, don't have any contact, and all will be well. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Downey. He'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you've taken off, I'm going to issue a warrant for your arrest. Just don't pick up any new cases, okay? We'll have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Judge, thanks, guys. Please. Given a arraignment?
Yes, it's for Blake Jenkins.
Okay.
And Judge, I showed up and he is wanting me off the case. He wants a new attorney.
Jenkins, come up, please. Okay, so why are we here on Mr. Jenkins? What happened?
Yes, he was on bond and there's a new offense, so we're here for an arraignment. And then,
So he's on bond for 2 cases. He's now picked up a 3rd case. Is this right?
that's correct, yes.
Mr. Jenkins, you now stand charged with the offense of reckless driving. You are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 12, 2025, at 6:26 p.m., the officer observed the defendant's vehicle traveling at a high rate of speed on a feeder road without headlights on. The officer checked the speedometer and it read 80 miles per hour while the defendant's vehicle was traveling faster. This occurred in a 50-mile-per-hour zone. The officer observed the defendant's vehicle make an unsafe lane change, cutting off a motor vehicle and reaching a speed of 106 miles per hour with moderate to heavy traffic. The officer observed another unsafe lane change while attempting to catch up to the defendant's vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle.
Mr. Jenkins, I'm going to find that there's probable cause to go forward with the case. Does he have a valid Texas driver's
Yes, eligible.
I'm now revoking your bond on the other 2 cases. You will go into custody with me because you picked up a 3rd case, sir. Goes with you.
Judge, he also is wanting me off the case. So I didn't know if we wanted to address that.
I'm not going to talk to you about this case. You have a lawyer. You need to talk to the lawyer.
Talk about my two kids before that, sir.
I'm not going to talk to you about this. We'll put you in back if you want. I can give you a new lawyer today. I'll give you a lawyer, another. If you want to get off, and I'll provide you another one. It's the 3rd case. Unacceptable. Mr. Jackson, you now stand charged with another case. You were charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 18, 2025, the officer observed the defendant's vehicle traveling 78 miles per hour in a 60-mile-per-hour zone, have an expired registration, and failed to maintain financial responsibility on Interstate 45. The officer noticed a prominent odor of marijuana trailing the defendant's vehicle, and a traffic stop was initiated. The officer observed the defendant to be in the driver's seat with a black bag and a female to be in the front passenger seat. The defendant rolled down the passenger window, and the officer observed a cloud of smoke emitting from the vehicle with an odor of marijuana. The defendant was asked to step out of the vehicle with the black bag. The black bag was opened, and the officer observed a clear jar with a green leafy substance known to be marijuana based on training experience, along with a digital scale and individual baggies. The defendant was searched for weapons, and the officer found more packages of marijuana inside his private area. The weight of the marijuana was 1.82 ounces.
And Your Honor, if I could adjust probable cause.
Okay.
Your Honor, so while I don't dispute the reason for the stop here, I think there's a couple things that stand out. So there is a alleged smell of marijuana that comes from the vehicle, and then an alleged cloud of smoke that comes from the vehicle as the windows are open. So first off, the officer doesn't specify whether this is a cloud of course, burnt marijuana, which I would assume, or vaped marijuana, because those are 2 very different things with 2 very different distinct smells. Additionally, if the officer is pulling him out and looking for marijuana and he has this cloud, then he would be looking for burnt marijuana, right? So he would be looking for a roach. He would be looking for a blunt. What he does is he looks inside of a plastic bag. If we have embered marijuana or we have a lit blunt, it's certainly not going to be in a plastic bag without the smell of burning plastic. Additionally, the marijuana that is found in the bag is in a sealed glass jar container, something that would not emanate a smell because a glass jar is essentially smell proof. In this instance, I think we have an officer who went too far with the search because we have Mr. Jackson here who did not admit to possessing marijuana, did not admit to this being marijuana. The statute, of course, requires that this has to be marijuana, and we know we have the issues, of course, with the hemp bill. Your Honor, if you're not aware, you can go into any head shop, purchase flowered hemp, open it, and it smells, looks, everything about it is identical.
I understand, and that, yes, I agree with you for a beyond a reasonable doubt standard, but here, this is just mere probable cause, right? There's a good stop, he goes to the car, he smells marijuana, there's a plume of smoke that comes out. Not only that, Sean, he signed an affidavit that he wasn't going to drive. He's not supposed to be driving regardless.
And I get the driving aspect of it, but I don't see how a cloud of marijuana from burnt marijuana gets you inside of a plastic bag. At that point, it becomes a fishing expedition as opposed to looking for the actual contraband, which he suspects that would be in the vehicle.
I don't know. I mean, I think that there's certainly enough to go forward. Beyond a reasonable doubt, I don't know. But this is just a probable cause standard, which is the low stand, So
I understand.
I'm going to find that there's probable cause to go forward with your case, Mr. Jackson. I ordered you not to drive. He's a driver in this car?
Yes, Judge.
Okay. I'm now revoking your bond. It goes with you. Sorry, Sean, but he promised us he's not going to drive. He signed an affidavit. He knows. Ma'am, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On January 16th, 2025, at approximately 10:25 p.m., the officer was traveling on East Sam Houston Tollway and observed the vehicle traveling at a high rate of speed, overtaking other motorists and changing lanes without signaling. The officer observed the vehicle get on Ship Channel Toll Bridge and pace the vehicle at 75 miles per hour in a 50 mile per hour zone. The vehicle further failed to drive in a single lane and a traffic stop was initiated. The officer made contact with the defendant, the driver of the vehicle, and observed the defendant to have slurred speech and odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The defendant was read the DIC and refused to provide a specimen, and a blood search warrant was signed and executed.
Ma'am, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming anything of this nature, I'm going to revoke your bond and put you in jail. Do you understand, ma'am?
There's no driver's license on file for the defendant.
Okay. Any prior DWIs?
No priors, Your Honor.
Okay. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I take it extremely serious. You just saw what happened. If you don't have a license and insurance, do not drive. Would you like to apply for a court-appointed lawyer, ma'am? Okay. What's going to happen now is I will have you swear to it that you're not going to drive without those 2 documents. I will have you sign a receipt with Victoria. We will have you get with Fleischer at some point for your bond conditions. In the meantime, we'll have you fill out an application, then I'll have you speak to a lawyer here momentarily. All right? Please. Good morning, Mr. Humphrey. So you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes,
You have the right to have an attorney present. If you're not afford one will be appointed to you.
Yes, Judge. The officer was conducting a follow-up investigation and spoke to the complainant. The complainant knew the defendant by name and sight as they were in a dating relationship for 2 years. The complainant stated they ended the relationship in 2023, but continued to be friends because they worked in the same building. The complainant stated she initiated contact with the defendant via cell phone. The defendant showed up at her location and talked. The defendant asked to hang out, but the complainant stated she was busy. The complainant left the location and got a call from the defendant, and the complainant told the defendant to leave her alone and hung up. The defendant called her 35 times and called her using a secondary number. The complainant blocked both numbers, and the complainant got approximately 100 calls from a no-caller ID number. The complainant answered, and the defendant told the complainant to unblock her, and the complainant hung up. The complainant arrived at her office and saw the defendant calling her and was knocking and attempted to open the door to her suite. The complainant was escorted to her vehicle, and the defendant contacted the complainant 39 times via his cell phone, 1 time via a secondary number, 6 times via email, and 100+ times from a no-caller ID. The defendant spoke to the officer and admitted to calling the complainant 100+ times from his primary phone number and his secondary number and sending emails because she blocked him.
Mr. Humphrey, I'm going to find that there's probable cause to go forward with your case. You're on bond for murder. You now picked up a harassment case. You're lucky to be out on bond. Now you picked up a new case. I mean, really. I'm ordering you as a condition of your bond not to have any contact with the complaining witness. I'm going to put a GPS monitor so I know you're not going anywhere near this person. I will protect my community at all costs. Do you understand, sir? You're not to consume alcohol, illegal drugs. I don't want you going within 1,000 feet of where she lives, where she works, no weapons. You know, life is really short. It would really suck to spend the next 50 years in a 6x9 box. There's so many fish in the sea. It's not worth it. You know what I mean? Really. Move on. Just, life's way too short. Really. Do you have the ability to hire a lawyer, Mr. Humphrey? Or do you need a court-appointed lawyer? Okay. Just, I want my community safe, man. That's all I want. Please. You know, please. I have an application on file already. So I'm going to have you sign a release of Victoria. I'm going to have you meet with Fleischer for your bond conditions. I'll provide you a lawyer here momentarily. Just think before you act. Come on. You are Jesus Montes. Mr. Montes, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer met with the complainant who stated that her and the defendant are married, and while at the defendant's sister's home, they got into an altercation. The complainant stated that the defendant grabbed her by the neck and pulled her hair, causing pain. The officer observed redness to the complainant's neck area.
Mr. Montes, I'm going to find that there's probable cause to go forward. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. There is a protective order that has been issued in this case. I would get to know it. If you violate the protective order, the state can and probably will file a violation protective order against you. It's one of the worst cases you can pick up. You understand? Do you have the ability to hire a lawyer, sir? Okay. We'll provide you a lawyer today, but don't pick up any new cases. Don't endanger my public. Do you understand? I'm going to have you sign a receipt of Victoria. We'll have you take a seat in the jury box while we get your conditions. We'll have you sign it, and then we'll provide you a lawyer here momentarily. You are Jonathan Caldwell.
Yes, sir.
Mr. Caldwell, you're charged with possession of marijuana and you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle traveling 35 miles per hour in a 20-mile-per-hour zone on Pine Dust Lane. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the defendant was not wearing a seatbelt. The officer further observed an odor of marijuana and asked where the marijuana was located. The defendant stated the marijuana was located in the back seat. The defendant gave consent to search the vehicle, and the officer found a clear plastic sandwich bag with a green leafy substance in the back seat and a glass container with a green leafy substance. The total weight was 0.921 ounces.
Okay, Mr. Caldwell, I'm going to find that there's probable cause to go forward with your case. Have you looked to see if he has a license?
It's not eligible, Your Honor.
Hey, you're not allowed to drive. If you don't have a license, do not drive. Do you understand? If you go get a license, if you get insurance, come back to me. I'll take this restriction off. That's your only condition. Don't get in trouble and don't drive. You understand? I'm going to have you sign an affidavit, which is a promise you're making to me. That's the only condition, Mr. Caldwell. Don't drive. Now, you have a lawyer. Remain in contact with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get in contact with you, I will revoke your bond. Just don't pick him a new case and be good. All right? Come on. Thanks, Mr. Cole. Good weekend. You too. Good morning, Mr. Barnes.
Good morning. Sorry, David. Sorry.
You made it out.
Yes, I did.
Just we're not asking for much, man. Just be careful, behave, don't do anything you shouldn't do, you know? Is those cases are still open in Fort Bend or what?
The current case is still open in Fort Bend. It's still pending. Your next court date is down there.
It's on March. Not all the cases are open.
One of them's still open. Paul Two's representing him. I talked to Paul yesterday, and it's set for sometime in March. I can't recall the exact
It's okay. Have we done PC on this yet or no?
We haven't done anything because he was in custody.
Right. Okay, so we're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. I just want to see if there's enough to go forward on your case. I don't know what happened. Okay, Alex, please.
Yes, Judge. On September 4th, 2024, the officer observed a hand-to-hand transaction between the driver of a parked vehicle and another individual. The defendant was a passenger in the vehicle, and the officer approached and smelled a strong odor of marijuana. The officer asked the defendant to step out of the vehicle and saw in plain view a scale in the driver's side door, and the officer detained the defendant and the driver. The officer found a bag of marijuana in the defendant's waistband pursuant to a pat-down, and the weight of the marijuana was 1.27 ounces.
Are you telling me he saw him do a hand-to-hand transaction or someone else?
The driver of the vehicle was a hand-to-hand transaction, and when he approached the vehicle, he asked the defendant and the driver who did the hand-to-hand transaction to exit. And furthermore, the officer smelled an odor of marijuana.
I know, but why would he search him?
What?
I get it on the driver because he sees the hand-to-hand contact with them, but he's just sitting there.
You're right. The only thing would be officer safety, just the pat down. That.
Yeah. All right, Mr. Barnes, I'm going to find no probable cause. Just be careful. All right. Really. You hang with dogs, what happens? No. You get fleet. Well, you can get bit too, right? Please.
He's a bad dog.
Just don't hang out with the wrong people. All right. Come on. We really have 4 open cases now with Miss Newton. What is your true name, ma'am? Miss Newton, you now stand charged with 2 more cases. You're charged with another theft case. You're also charged with failure to identify oneself to a peace officer. You are facing up to 6 months in jail and or a $2,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On January 17th, 2025, the officer was dispatched to JCPenney's regarding a theft or shoplifting. The officer made contact with the complainant, a loss prevention employee, who stated the defendant, Newton, and a co-defendant, Woods, entered the store, selected several items, put the items inside a personal bag, and exited the store, passing all points of sale without paying for the concealed items. The complainant stopped the defendants outside and escorted them back to the loss prevention office. While at the office, the defendant identified herself as Christiana Ray to the officer. An APHIS search came back to reveal the defendant's real name with an outstanding warrant out of Harris County, Texas. The total value for the items was $268.
She has a theft from December of 22, a theft from June of last year, and now 2 more cases. Was she on bond for either of these cases when she picked up the 2 new cases?
Let me see, Your Honor. It appears bond was made after the new cases. On the 19th, the new cases were picked up on the 17th.
On the 251, it appears she posted bond only one time on the 19th of this month. On the 243,
Yes, Judge, on the 243.
that's the one that was in
GOP.
current status, right?
Yes, Judge.
Where are all those from?
So the theft, cause number 243 was a Dick's Sporting Good.
Dick's,
and then 251 theft was a Sephora, and then the most recent theft was a JCPenney.
Miss Newton, Miss Williams, I'm going to find that there's probable cause to go forward with the case. I'm now putting a monitor on your ankle so I know where you are at all times, and you are forbidden from going to JCPenney, any JCPenney. You're forbidden from going to any Sephora. You're forbidden from going to any Dick's Sporting Goods. If you pick up a 5th case, I tell you now, your bond is going to skyrocket. Do you understand, ma'am? Would you like to apply for a court-appointed lawyer, ma'am? I'm going to have you sign a reset with Victoria. After that, you'll get with Fleischer for your bond conditions. Do not pick up the 5th case. I'm telling you now. I don't know what you're doing, but you pick up another case. Please, ma'am. Morning, Mr. Price. Sir, you're charged with two cases. You're charged with assault of a family member. You're also charged with a garden variety assault. On both of those, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The complainant, Terrell, and the defendant were in a previous dating relationship. The defendant followed complainant Terrell into a bathroom of a bar and began to slap complainant Terrell multiple times in the face, struck complainant Terrell with a closed fist multiple times in the face, and grabbed complainant Terrell by the throat, but did not impede breath. The defendant would not allow the complainant to leave, and complainant Asher, friends with complainant Terrell, walked into the bathroom. The defendant struck complainant Asher in the face with a closed fist.
Who?
So complainant Terrell is the AFM and complainant Asher is the ABI.
Terrell, is that a...
That is a dating relationship.
Got it. Okay. Mr. Price, I'm going to find that there's probable cause to go forward on both of your cases, and I'm ordering you not to have contact with either person. Do you understand? I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Terrell as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat of harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Pierwood Drive house. Do you understand? If you violate this court order, the state can and will file a violation protective order against you. It's one of the worst cases you can pick up. So you're also not to have contact with the complaining witness in the assault case and not to be in possession of weapons as well. We're going to file these conditions. You will need to sign it. Did you need a court-appointed lawyer today, Mr. Price? Okay. You can reach out to the MAC. I've got an application on file. I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the jury box where we get all your bond conditions. You'll sign it, and then we'll provide your lawyer here momentarily, sir. You were Jamarcus Randolph. Mr. Randolph, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine on that one. You're also charged with possession of marijuana. On that one, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle bearing a temporary buyer's tag with an expiration date of December 25th, 2024. The officer ran the expired buyer's tag through NCIC and observed the license plate to not be registered to any vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the front seat passenger. The defendant admitted to having printed the buyer's tag himself and putting it on the back of the motor vehicle. The defendant stated he printed the buyer's tag at UPS or something. The officer observed a strong odor of marijuana, and the defendant admitted to smoking earlier that day. A PC search of the defendant's person and vehicle were conducted. The officer located a small plastic bag containing a green leafy substance known to be marijuana based on training experience in the defendant's front right pocket, and a clear plastic bag containing marijuana in the center console of the vehicle. The weight was 0.3 ounces.
All right. Mr. Randolph, I'm going to find that there's probable cause to go forward on both of your cases. Can you look up to see if he has a...
It's not eligible, Your Honor.
You are not allowed to drive. I don't care what's going on in your life, Mr. Randolph. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, it's not going to go well for you. Do you understand? If you want to drive, go get a license, get liability insurance. If you can show me that you have both of those things, I'll take this restriction off. But I'm going to tell you now, if I find that you do, it's really not going to go well for you, sir. Did you need a lawyer today, sir? Okay. Let's see. Show file. I need you to fill out an application for me. I can provide you a lawyer today. Above all else, in the short life that we have, do not drive. This is an affidavit that you're going to be promising me you're not going to drive. Do you understand? All right, come on. You're a Kiana Ware. Miss Ware, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 19th, 2025, the officer was dispatched to a two-motor vehicle accident on the 1900 block of Southwest Freeway. The officer observed the defendant's vehicle with damage to the front right side, and the officer made contact with the defendant who was observed to have a strong odor of an alcoholic beverage, slurred speech, bloodshot, glossy eyes, and poor balance. The defendant stated she was coming from a friend's house, was driving home, and had drank 7 glasses of wine. The officer observed the defendant to be emotional and have changes in mood, and a witness, the other vehicle involved in the collision, observed the defendant in the driver's seat. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 4 out of 4. The defendant was read the DIC and refused to provide breath. A blood search warrant was signed and executed.
Ready to be honest? Can you
No,
run
Your Honor. And
your
eligible driver's
NCIC?
license.
Have you run your NCIC?
Yes, Judge, and there's no prior DWIs.
Right, ma'am, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I'm going to revoke your bond, put you in jail. You understand, ma'am? Okay. Did you need a lawyer today, ma'am? Okay, we will provide one to you. I need you to fill out an application for me, and then I'll have you speak to someone. Don't use. That's all I'm asking you to do. Don't pick up any new cases. Don't be a danger to my public. Do you understand, ma'am? Okay, come on. Miss Williams, ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 13th, 2025, the officer was dispatched to a disturbance regarding a female in a motor vehicle on Westheimer Road. The officer observed the defendant stopped in the parking lot of a gas station and the officer observed the defendant exit the vehicle from the driver's side while holding her keys. The first and second complainant had previously seen the defendant driving between 2 gas pumps, hitting a trash can before stopping in the parking lot. The defendant proceeded to walk towards the officers, who observed the defendant swaying side to side, observed bloodshot, glassy eyes, observed poor balance, and a strong odor of an alcoholic beverage. The officers then detained the defendant and performed standard field sobriety test, HGN 4 out of 6, walk and turn 7 out of 8, and one leg stand 3 out of 4. The defendant was read the DIC and agreed to provide a specimen of blood.
Okay, any priority to be honest?
No, Your Honor.
And I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. Do you understand, ma'am? Did you say she has a valid Texas driver license?
I'm running it right now, Your Honor. It's eligible, Your Honor.
Okay, you can drive as long as you have a license and liability insurance. If you don't, do not drive. Do you understand? Do you need help with a lawyer today, ma'am? Do you want one? You need one. Okay, I'll provide your lawyer today, but so for now, I'll have you sign a wreath, Victoria. You will have to meet with Fleischer of your bond conditions. For now, we'll have you take a seat in the jury box while we find your lawyer, okay? Mr. Lestrep, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On September 16, 2024, officers were dispatched to a Walgreens in Harris County, Texas. The officers spoke.
Same Walgreens as always?
Yes, Judge, it is. And the officer spoke with the complainant, the store manager, who stated she knows the defendant by sight and name. The complainant was able to identify the defendant and stated the defendant is a habitual shoplifter at the location. The defendant has a trespass warning from January 24th, 2024. And on the 17th of January 2024, the defendant stole a total of $145.81 in merchandise. On the 24th of January, the defendant stole $100.71 worth of merchandise. And on July 17th, 2024, the defendant stole $105.80 worth of merchandise. On August 1st, 2024, the defendant stole $43 worth of merchandise. And on August 15th, the defendant stole $70 worth of beer. On September 16th, the defendant stole $70.49 worth of merchandise. On November 30th, 2024, the officers stole $30.25 worth of beer. The total value for all thefts was $506.86.
Let's go out of jail. Mr. Lestrep, I'm going to find that there's probable cause to go forward with the case. I'm ordering you not to go back to this Walgreens. I'm putting an ankle monitor on you right now. If I find that you violate this, you go within 1,000 feet of this store, I'm going to revoke your bond. I'm going to put you in jail. No more PR bonds. Do you understand, sir? 1,000 feet you're not to go within this Walgreens. Do you understand?
Yeah.
I will provide you a lawyer today, Mr. Strauss, but I'm done. This is it. I'm going to have you sign a reset. You'll get with Fleischer for your bond conditions, and then I'll have you talk to a lawyer here momentarily, Mr. Lestrade. Mr. Hayes, you were charged with assault of a family member. You are facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Actually, you're charged with 2 counts of assault. You're facing up to a year in jail and/or a $4,000 fine. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On June 3rd, 2024, the officers were dispatched to an aggravated assault call, and the officers met with 2 complainants. The first complainant was in a prior dating relationship with the defendant. The second complainant is the first complainant's mother. The first complainant stated the defendant and her were at a party when the defendant started to become upset, and the first complainant was not responding to his advances. The 2 got into a verbal altercation, and during the verbal argument, the defendant punched the first complainant in the face several times, causing pain. The second complainant stated she observed that the defendant and the first complainant were in a verbal argument and went over to intervene, but was struck in the face with a closed fist by the defendant, causing pain. The defendant then left and returned with more family members, and the first complainant stated the defendant continued to assault her until gunshots were heard and the defendant fled.
Hey, stop.
I'm sorry.
Do we know if alcohol played a part in any of this?
There are no allegations of alcohol, Your Honor.
Mr. Hayes, I'm going to find that there's probable cause to go forward on both of your cases. In both of your cases, protective orders have been issued. I would get to know them. If you violate the protective order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up. Do you understand? I am ordering you not to have any contact with either of these people at all throughout the duration of this case and not to be in possession of weapons. I'm going to do everything in my power to protect my public at all costs. Be aware of that. If I find that you pick up a new case, you endanger my public, I will revoke the bond, put you in jail, and I'm going to make them extremely high. You have a lawyer. I don't know where your lawyer is, but because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with the lawyer. If the lawyer tells me he can't get hold of you because you're playing games, you're not responding to phone calls, text messages, I will issue a warrant for your arrest. For now, I'll have you sign a reset. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then we'll just wait for your lawyer to get here, sir.
And my lawyer's going to be coming here.
I don't know. He's not here yet, so hopefully he shows up. You are Mr. Jointer, right?
I am, Your Honor.
Okay, so tell me what's going on.
So he is, the court is aware, out-of-state fugitive. He has waived his extradition. We were here to see if the court would entertain giving him essentially an extradition bond.
Okay. Do you mind bringing out Mr. Huggins, please? Good morning, Mr. Huggins. So understand that your lawyer is here because he wants me to set you a bond. I don't know anything about you. I've never met you before. I know that you're going to tell me it's little bunnies jumping in the woods, but really, what matters to me are 2 things. Number 1, what are you charged with? Are you a dangerous person? And more importantly, most importantly, are you going to go back to the demanding jurisdiction? I have no idea. We have to get to know you in the short time now, 20 seconds, just to see who you are. So, Mr. Kim, tell me about it.
Yes, Judge. Defendant is wanted at East Baton Rouge Parish, Louisiana for a domestic abuse, battery, strangulation, or equivalent of impeding breath. State would be opposed to bond. Defendant is currently on deferred adjudication for aggravated robbery, where he was the driver and there was a firearm involved. During the aggravated robbery deferred, he picked up a misdemeanor possession of marijuana, which alone, that wouldn't be sufficient to bring up the court. But the fact that one of his conditions on his deferred adjudication was to not consume any marijuana, he violated said provisions, and then now he picks up a strangulation. The warrant was 10 days old when he.
So this case here, this is a new case.
Yes, Judge. It was issued out January 14th. And so because of the repeated violations, the offense being one of them, the state would be opposed to bond.
If I may, Your Honor.
Please.
Mr. Huggins has already retained counsel for the New Orleans case. Eric Hayes, I have been in communication with him. I think it's important for the court to know, as it relates to the allegations out of Baton Rouge, that it was actually the complaining witness mother who hired us to be here this morning on behalf of Mr. Huggins. I also think it's important for the court to know, even though it is triable facts for the Louisiana case, she also sent us over several videos. We're confident that he will appear in New Orleans because he's already retained counsel. We believe that he won't have a problem complying with all of the things that's been outlined here in Harris County, seeing that he does have strong ties to the community and he is employed. And because of that, Your Honor, we do believe that there are conditions that can be put in place if the court elects to give him a bond, such as an ankle monitor, to ensure that, one, the court knows where he is and that the community is safe. And then also he has already retained counsel, Mr. Eric Hayes, for that matter out in Baton Rouge. So I believe I have no reason to believe he won't answer to Baton Rouge, and I don't have any reason to believe he won't comport with the conditions here in Harris.
You're a dangerous person, man. How old is he? 22, 23?
Yes, Judge. And to add, for what it's worth, he already had a GPS ankle monitor as a condition of his deferred when the strangulation happened, or at least according to the conditions. And
Was he not supposed to go there too?
No, it's just one of the arguments made by counsel was to have a GPS monitor secured.
This is that, it's just such a short time. He's picked up this case. He picked up, I guess, a weed case, and he's on probation for an aggravated robbery. I mean, really.
Full disclosure, there was a motion to adjudicate, but in the Brenham case that was dismissed. I don't have the files for the Brenham one, but I presume because the deferred was cured that they didn't pursue it. But he was only charged and it was later dismissed, but it was 2023. So obviously very recent.
Let me ask you this. Is he on bond for did they file a motion to adjudicate on the
aggravated robbery, but then that was dismissed on October 16th.
So he has no holds now, right?
Currently, yes, Judge.
And it was dismissed because the Brenham marijuana case was ultimately dismissed.
Yes.
I'm not comfortable giving you a bond now, Mr. Huggins. I think you're a dangerous person, man. You picked up that case over there. You're on probation for an aggravated robbery where there's a gun, and I don't know if there's shooting involved, but the good news is that it's only Louisiana. We have buses coming in and out probably 2 times a week to take people back because we have so many people from Louisiana here. So once you waive extradition, Monday, Tuesday, you'll be back in Louisiana. So he's not going to be sitting for not too long. I don't feel comfortable doing it, man. You scare me, dude. So he said he has waived, right?
Yes, Judge.
Sorry, counsel. But the good news is that he'll be back lickety split, in was it Lafayette?
It's East Baton Rouge, currently the aggravated robbery doesn't have a new MAJ based on the impeding or the strangulation, and so I can't speak for the trial bureau, but if they decide to revoke.
Huggin, you got to understand, when you're on felony probation, something like that, you got to live with a halo on your head, because you could be looking at 20 years, man. All right, thanks.
Thank you, Judge.
Yes, up to a year in jail and/or $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Give the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
Yes, Judge. On January 18th, 2025, the officer observed the defendant's vehicle stopped and impeding the moving lane of traffic, with other vehicles having to honk and go around on the 2300 block of Bagby Street. The officer honked and used sirens multiple times to get the driver's attention, but the defendant chose to ignore him even after the passenger advised the defendant that the officer was attempting to get her attention. A traffic stop was then conducted, and the officer observed slurred speech, glossy eyes, and a strong odor of alcoholic beverage. The defendant admitted she drank 2 beers while at a memorial in downtown area, and the officer had the defendant exit the vehicle and observed unsteadiness on her feet. The defendant refused to answer anything else and was uncooperative on the scene. At JPC, center sobriety were conducted, HGN 6 out of 6, walk and turns 7 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused breath. A blood search warrant was signed and executed.
And I'm going to find that there's probable cause to go forward with your case. You have a valid Texas driver license.
It's eligible, Your Honor.
I am now placing a restriction on your license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, you will go to jail because I will revoke your bond. You're also not to consume. Shh.
Or step outside and talk.
Not to consume alcohol, illegal drugs, or unprescribed controlled medication, and I'm going to randomly test you. If I find that you're using, likewise, you will go to jail, ma'am. I'm sending information to DPS so that every single officer in this state will know if you get pulled over, they will know that you're to have an interlock in your car. So if you're caught driving a vehicle that doesn't have one, they will take you to jail. Do you understand, ma'am? Do you have the ability to hire a lawyer, or would you like a court-appointed lawyer, ma'am? Sorry? You're going to hire a lawyer. Okay, so what we'll do now is I'm going to have you sign a receipt with Victoria. We'll have you meet with Fleischer for your bond conditions. After that, we'll get you out of here. And then when you come back, please have a lawyer. Okay. Mr. Corral, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Mr. Judge.
On October 18th, 2024, officers were dispatched to a family assault and made contact with the complainant, who stated that she and the defendant are dating. The complainant stated that they got into an argument. The defendant grabbed the complainant's arm and squeezed, causing pain. The complainant stated she punched and struck the defendant to get away. The complainant stated that the day prior they had gotten into an argument and the defendant grabbed her by the arm and squeezed while the complainant fought to get away. The officer observed bruises on the complainant's arm.
Got it. Mr. Corral, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate these conditions, I'm going to put you in jail by revoking your bond. Do you understand? I don't see a protective order that's been issued. Has one been issued in this case?
I see it as of 10/19, Judge.
No, but it's not been signed. Corral.
Yeah.
Entering in what's called a mattress order of emergency protection that identifies Ms. Cabrera as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the East Tex Freeway Apartment 4304. If you violate this court order, the state can and will file additional charges against you, including a violation of protective order. It's one of the worst cases you can pick up. So know what you can and can't do before you leave this place. Do you need a court-appointed lawyer, Mr. Corral? Okay, I'll appoint your lawyer today. Do not leave until you sign all our bond conditions. Otherwise, a warrant will issue. Please. Ms. Delgado Ortiz.
Yes.
Ma'am, you are charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 12th, 2025, the officer was dispatched to a disturbance at a residence in Harris County, Texas. The officer made contact with the complainant, who stated that he and the defendant had been dating for 8 months. The defendant is about 5 months pregnant with their child, that he and the defendant got into an argument earlier that day, and that he left to go speak with his sister because he was contemplating breaking up with the defendant. The complainant stated when he went back to the residence to grab items, the defendant began arguing with him again. The defendant told him she was going to break his TVs. The complainant began recording. The defendant threw Xbox headphones and threw them at the complainant, hitting the complainant in the right hand, causing pain. The defendant then approached the complainant, tried to grab the cell phone out of the complainant's hands, grabbed the complainant's hair on the right side with one of her hands, and pulled, causing pain. The defendant stated she and the complainant got into an argument over money, and the complainant threw her clothes on the ground. She got upset, threw the headphones on the ground, but that she did not throw the headphones at the complainant. The defendant further stated she got upset because the complainant was recording her. She attempted to grab the phone, and the complainant grabbed her hair and pulled, so she grabbed his hair and pulled. The complainant then attempted to throw her on the ground, and she hit the floor, causing pain.
Ms. Delgado, I'm going to find there's enough probable cause to go forward with your case. A protective order has been issued in this case, and I would get to know it. If you violate the protective order, the state can and will file additional charges against you. I am ordering you not to have any contact with this person and not to be in possession of any weapons. I don't know what your immigration status is, but if you are not in the country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck in there. Do you need a court-appointed lawyer today, ma'am?
Yes.
I will appoint your lawyer, but I'm telling you now, do not pick up any new cases. Do not violate any of these conditions. Otherwise, I'm going to put you in custody. Do you understand?
Yes.
Okay. Do you mind filing those conditions, Alex, please? Okay. For now, I will have you sign a reset with Victoria, and then we will have you take a seat in the jury box while we find your lawyer. You are Dennis Fisher.
Sir.
Mr. Fisher, you're charged with discharging a firearm in a metropolitan area. You're facing up to a year in jail and or a $4,000 fine. This case is super old. Every time you take off, every time you go, we revoke your bond and just raise it. And all you're doing is you're giving away free money to bonding companies every single time. Do you have a lawyer today?
No, sir. No, sir.
Okay. Would you like me to appoint you one? I'm going to appoint you one, and I'm going to tell you now, you take off on me again, I'm going to make your bond so high, you're going to not know what to do with yourself. Do you understand? Okay. Reaching out to the MAC for Mr. Fisher as well, please. Okay. I am ordering you as a condition of your bond not to be in possession of any weapons whatsoever. You understand? Okay. Do you mind filing that, please? All right. Just take a seat. We'll have you sign a reset. This is Mr. Jones, right?
Yes.
Mr. Jones.
Judge,
You were-
I don't think it was that they picked up a new case. It was just that they were separated.
No. One, we have an assault from September of 24, and he picked up a DWI January 19th,
When was the assault filed?
right?
It's not Jones, Judge?
Yeah.
Assault was filed September 10th, and then the DWI filed January 19th.
Judge, it was an open one for a long time. Bond was never closed in.
So the 2B gets filed September 10th of 24. KPS issues on the 12th. Yeah, I guess you're right. So, Mr. Jones, you're charged with two cases. You're charged with driving while intoxicated. You're also charged with assault of a family member. On the assault case, you're facing up to a year in jail and or a $4,000 fine. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On which case, Your Honor?
Both. But both.
The
Dealer's choice.
Yes, Judge. So on KFM on June 24th, 2024, officers were dispatched to a disturbance. The complainant and the defendant were in a verbal argument over his driving, and the defendant continuously made threatening remarks to the complainant until they arrived at their apartment. The complainant locked herself in her bedroom, and the defendant kicked in the door. The complainant tried to flee the apartment, and the defendant grabbed a kitchen table chair, lifted it above his head, and slammed it on the complainant's head, causing pain.
Gosh.
The officers observed the complainant had open wounds on her right pinky finger, the inside of her right forearm, and her upper neck chin area. And then on the DWI, on January 18th, 2025, the officer was dispatched to a traffic hazard on Airport Boulevard in Harris County, Texas. The officer met with a wheel witness who said he was driving when he saw a truck that was stopped and turning off in a moving lane. The wheel witness went to the truck and saw empty beer cans in the bed and the defendant in the driver's seat. The wheel witness said the defendant appeared to be intoxicated, so he called police. The officers made contact with the defendant and noticed an odor of an alcoholic beverage, watery red bloodshot eyes, and slurred speech. The officer asked the defendant to step out of the truck and noticed the defendant was swaying. The defendant said he was coming from his mom's house and had two 12-ounce beers prior to driving. The defendant refused to participate in Centerfield sobriety tests. The defendant was read the DIC and refused to provide a sample. A blood search warrant was signed and executed.
Is there alcohol in the car while he's driving?
No, Your Honor.
And Judge, if you look at his eyes now, his eyes are red. I think that's more of a medical condition than anything.
As far as the assault is concerned, he had an assault that was dismissed in 23. Is this the same complaining witness, Alex?
Yes, Judge.
Mr. Jones, there's a protective order that has been issued in this case. I would get to know it. If you violate said protective order, the state canon will probably file a violation of protective order. That is the capital murder of misdemeanors. Do you understand? It's one of the worst cases that you can pick up. I am ordering you as a condition of your bond not to have any contact with this person whatsoever, and not to be in possession of any weapons. I'm also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, you will go to jail. No more PR bonds. Do you understand? Any prior DWIs, can you run a full NCIC, please? And does
Yes,
it have
Judge.
and
And
does he
there's no prior DWIs.
Texas driver license?
I'll run that right now, Your Honor.
Please.
Your Honor, the driver's license says eligible in our system.
Okay. Like I said, you're not to have any contact with the complaining witness in this case. I don't care if she calls you. You have contact with this person, then I'm going to put you in jail. If she calls you, do not answer the phone. If she calls you from an unknown number, you hang up the phone. If she texts you, do not reply. If she comes to your house or wherever you may live, don't answer the door. But if I find that you have any contact with this person, it's just not going to go well for you. I've given you a lawyer. It is your responsibility to stay in touch with Mr. Perez. He will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, likewise, a warrant will issue for your arrest. I'm going to do everything in my power to protect this community in every single way. Do you understand? Okay? All right.
Thank you.